My friends, I just pressed the let's go live button, which means we've got to wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, my headphone was not plugged in. That's how we know we're a little bit rusty after the weekend. It was not a long weekend, it was just a weekend. But the tubes are working, which is good news, even though yours truly can't connect my tubes over on the back end here. The other tubes worked all across the internet. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Trump trials. We've got Don Jr., who is on the stand in Tishy Latish James in her courtroom. Judge Engoron's courtroom, or let's say, Judge Greenfield's courtroom, his law clerk. But we're going to talk about what's happening here today because the defense started their case in chief today. Don Jr. was back in court. We know that Tishy called him as a witness in the government's case. But now, since the defense is presenting theirs, we're going to hear what Don Jr. had to say. He testified a bunch today, and there were some other clips from him as well that we'll poke through. But we also had Alina Habba. Of course, she has been gagged by Judge Engoron, and I'm sure she's not happy about that. And she says we're going to be filing papers, and that paperwork is going to settle a lot of this or explain a lot of this. But questions about mistrials, questions about what can be done about this judge and about this scam show trial that is taking place there. We've also got some X-script threads that we'll be jumping into. We'll see what Inner City Press is reporting along with Klasfeld, who are on the X platform. And of course, both of those gentlemen are there at the trial and reporting live. So we'll go through some of their X threads. Be sure you're giving them a follow if you want to follow along in this trial. We're going to take our attention over to the January 6th case because Donald Trump is demanding that the trials be televised. And we've wanted these to be televised for a long time. We know that federal court precedent says you're not allowed to televise these things. But Trump and his defense, they submitted a motion saying, let's go. I want all America to see this. And I would think that's what the government wants, right? I mean, they keep telling us he's this big insurrectionist and that all the evidence is so clear and that everything that's taking place there is totally above board, right? Well, then why is Jack Smith objecting to any media at all, even any audio, nothing? They don't want anything happening. Well, it's because they don't want you to see their corruption. Otherwise, we'd be able to point it out. And so we'll go through a couple of these filings because they're good. Jack Smith objected to the media. This is a different type of filing. Think of it like the media is suing to get access. They're filing an application. They're filing think of it like a complaint. And so Trump is responding to that, and Jack Smith is responding to that. He's objecting to it. And so he's whining about Trump, saying, Trump always wants everything. He's going to turn this into a media circus if we put the cameras on, blah, blah, blah. Even though we just heard from Liz Cheney for 8 circuses in a row, however many times she was in front of the fake committee. And then lastly, we had a big, very interesting ruling that dropped. This one coming out of Georgia, and it involves this judge. Her name is Judge Amy Totenberg, and she was appointed by Obama, all right? And she came out in a federal court called the Northern District Court of Georgia. And we're going to go through it. Federal judge. Case is Curling versus Raffensperger. You remember that guy from 2020. Some people might say he botched 2020, or maybe he did exactly what they intended to do. But there was a case called Curling versus Raffensperger. It's an old case, okay? This was filed back in 2017 originally. I want to show you the docket. We just got an order on it over 6 years later, and the order is going to tell us, oh, we found some serious problems with Georgia elections. And you're kidding me. No kidding. Like broken water mains when they're counting ballots, when they're counting absentee ballots. No, there's no corruption at all. No, I'm sure it's all just above board over there. So the judge, the Obama-appointee judge, is really hitting this hard. It's about the opinion, I believe, is 135 pages, if I'm not mistaken. And so we'll hit the highlights of it and see what we've got inside there. But my friends, as you can see, we got a lot to get to today. It is going to be a fun show. We've got some trial stuff. We've got some court documents and other business to attend to. This morning on our members only stream, we had a fun conversation about what Trump was up to this weekend and what Tucker was up to this weekend. They were hanging around at the UFC, and the UFC was where they were hanging out. And so I want to make sure the audio is good over here. That Tucker was there. Bongino was there, Kid Rock was there, Trump was there, Dana White was there, Don Jr. was there. He got cut out of the photo, and it was a wild scene. And so we talked about that all over this morning, along with some other things. We talked about the fire under the bridge in LA and what that's looking like, and just a ton of stuff. So come and join us. If you'd like to get some extra content, meet some other amazing people, come and join us on our members-only community, watchingthewatchers.locals.com. But, my friends, before we get into the show, we're excited to welcome back our friends at Field of Greens. Oh, they're back. And so, of course, we want to say shout out to them and make sure that we're doing what we can do to be healthy, because Field of Greens is the healthiest thing that I do every day, and I wouldn't want to live without it. This nutrition is the way nature intended, and I know when I take my Field of Greens consistently, I feel great. And I've heard some of the same things from you. People have told me, and I feel the same thing, way more energy throughout the day. Skin looks healthier, helps with digestion, stomach feels a little bit more settled, hair and nails grow faster, look a little healthier, just overall, feel better, feel kind of healthier, feel like a little bit more pep in the step, as it were. And so that's how I know the Field of Greens is working for me. Field of Greens, as we can know, is a radically different, each organic fruit and vegetable. If you look at the label, you'll see it was medically chosen to support heart and vital organ health. And with flu season here and right around the corner, I trust Field of Greens to keep me healthy. Now, I promise that you're going to love this product, but if for any reason you don't, they'll give you a 100% money-back guarantee. And here on Watching the Watchers, we got a smoking deal, 15% off your first order with free rush shipping when you go to fieldofgreens.com. And don't forget to use code Robert. That's the promo code here for Field of Greens. So it's fieldofgreens.com, code Robert, and you'll be saving 15% off your first order with rush shipping. We're excited to hear from our friends at Field of Greens, because the vegetables, they want to be eaten, my friends. That's why they're here. And so make sure you check them out, fieldofgreens.com, code Robert. All right. Now, without any further ado, let's get right into the program, because we're back. Donald Trump's defense starts its case in chief in New York City's civil fraud case brought by Tishy Latish James. And the first person back on the stand was Don Jr. We already saw that Tishy called him to testify as part of the government's case. But now that Trump is going, Don Jr. takes the stand. And we're going to go through it. We're going to take a look at the photograph of him seated in court when the media got their cameras out and went hog wild. We'll also hear from Alina Habba and then jump right into the trial transcripts, courtesy of Inner City Press and Klasfeld Reports. But before we jump into the activities, Alina Habba was out over the weekend, and she was explaining a little bit about what happened previously. Of course, she's been one of the attorneys there in the Trump case. We've been hearing from Judge Engoron. We've been seeing him literally gag the lawyers. And when the lawyers say, "Can we file a motion to object to your gag?" they say, "Don't do it, Chris." What the heck am I supposed to do, Judge? I'm a lawyer. I have a client, and they're sitting right over there. Hello, I have to do something. And so the question is, how far can this thing go? Is this justice in America now? Like, is this the new standard? Or what is the defense going to do now that we get some of this stuff under the belt? And remember, we got to get some stuff under the belt before you can complain about it. You can really make the case in court, but it's going to hit an apex, and then they'll be able to file this, take it to the appeals. We're seeing judicial complaints be filed. Elise Stefanik filed one as a citizen of New York. And so the pressure is starting to cook a little bit. Here's what Alina says.
You have been complaining about the judge's clerk, and you say that the judge is compromised and the clerk appears compromised. Tell me why.
Well, I actually can't tell you why, because I'm gagged.
Right.
I can tell you that, we'll be filing papers to address all of those issues. And the fact that, frankly, Maria, I can't even discuss it with you, and I'm his spokeswoman, I'm his attorney, says a lot about what the judicial system, the state of our judicial system right now.
I think I did see that there were donations that the clerk had given, very supportive to the Democrats. That was one issue. Are you going to file to get a mistrial?
Yes.
When will you do that? Today?
Soon.
Yeah.
Very soon.
Okay.
Okay, so a mistrial's coming down the pike. We also know that there's some gag order problems that they're going to have to be battling around. And so she's being very careful there about what she can say, because she's been gagged, because Judge Engoron doesn't want any of the lawyers commenting about his little love notes with his Greenfield, his law clerk, sitting right next to him. He's like, I don't know if she's massaging him or what's going on, because the lawyers can't really talk about it. And, we know the media wouldn't report on it. So I don't know what's going on there, underneath that desk or whatever's happening. So anyways, here's Don Jr. in court. Of course, when the trial starts, they let in all the media come out in the front, and here he is sitting there just like, all right, here we go again.
The fact that the Trump sons, the Trump organization, did not try to have this conspiracy to defraud banks and insurers to get special rates on their properties by inflating those financial statements. Now, if you remember, Don Jr. was on the stand as a state's witness just about 2 weeks ago, and he distanced himself from.
Look at her. Oh, man. It's every day. She's sitting there literally behind the bar. She's like observing, like with these other people. She should start tweeting like a live tweet thread or something about this. She is the New York State Attorney General. Okay. She's one of the most powerful people in the whole state. And she is sitting here behind the bar, not doing anything all day for weeks, just sitting here and observing like a law school student. It's incredible. Now, I don't know, like literally, I don't think she's doing anything. She's seated at the same spot. The cushions are now tishified into the tish. And it's just like, oh gosh, they're gonna have to replace the whole bench.
Being, one of the top heads of the Trump organization and preparing those financial statements. So when he takes the stand for the defense.
All right, so there's Tish, not doing much of anything. All right. Anyways, the other lawyers who were actually doing things, they were there. And so let's jump right into the trial. We'll get started and warmed up here with Adam Klasfeld, who is there reporting. He reports over for the Messenger, and he says, good morning. We're in New York. He says, Don Jr. slated to return to the stand, and we already know some backstory on him. He says the government lawyers entered the courtroom. Don Jr. went into the building. Protesters shouting at him. Now, Don Jr. enters the courtroom, and testimony begins. He swears him in. They call it, Your Honor, the defense calls Don Jr. And this is Cliff Robert, who brings him up. Don Jr. goes in, promise to tell the truth about God. Yes, I do. All right, very good. Please proceed. So he goes in. All right, and he says, all right, Mr. Trump Jr. Good morning. And he says, good morning. I want to ask you a little bit about your education. He says, well, I'm very smart, a lot of education. I want to ask about some other areas in your life and kind of where you went in the early part of your life. He says, well, when I was a younger man, I moved to Colorado. I was working as a bartender there. I was actually there for about 18 months. Loved it. Beautiful town. And I enjoyed being a bartender. But then, after the 9/11 attacks happened, something happened, and I decided I was inspired, and I wanted to go over and join the Trump organization. And so we pick up here with Don Jr., and we have some other conversation. He says, let's jump around. He says, so Don Jr. rattles up some properties. He says, okay, so then you went to work for the Trump organization. And when you worked for the Trump organization, tell me some of the work that you did. Well, gosh, the Trump organization is a big deal. We did a lot of things. I worked on several real estate projects, for example. Trump Park Avenue was one. Trump Tower Chicago was another one. Trump Las Vegas. Man, I was all over the place. We were busy. Some people saw incredible value in the Trump brand, and they just wanted to set us up all over the place. And he says, well, tell us about how things would work, Mr. Trump, when you're there with your family. Obviously, there's a lot of moving parts. How did it kind of work? He says, well, the modus operandi there, the way that we kind of did things with my siblings and so on, he said, well, I think it was more of a meritocracy than title. Like, yes, our last name was Trump, but it was really a meritocracy. Like, my dad didn't want people playing around with this stuff. And just because we had a Trump name doesn't mean that it's all given to us. We got to work hard for it. And he says, well, tell me about, what your position was. He says this, and tell me about your siblings' positions. And they say, Eric Trump and Don Jr. and Ivanka Trump, they served as executive VPs for the Trump organization. What was it like sharing executive vice president positions with your siblings, Mr. Trump? He said, well, we work collectively. You know how it is with the siblings, younger brother's a little punk. But anyways, we worked collectively, but each of us had our own sort of projects. And so we made it happen. Now, I want to ask you, Mr. Trump, about these questions you got about being a co-trustee of Donald J. Trump's revocable trust and the company that holds the ex-president's assets. You're familiar with this? He says, yeah, of course. He says the other co-trustee was Alan Weisselberg, and technically his title was business trustee. Is that true? And he says, well, yeah, I mean, here's how it worked. You know, at the Trump Organization, there were various buckets, a lot of different things that we were working around. Business development, hotels development, golf courses. We had a licensing entity, all sorts of stuff, a lot of stuff. Okay, thank you for that. Well, I want to show you a document here, and it's put on your screen here. It's labeled The Trump Story. Are you familiar with this, Mr. Trump? Objection! Colleen Faherty stands up. Objection is what she says. And she says, Your Honor, I haven't seen this document before, and I don't know what is going on here. She says, I object to this sense of this narrative that we're getting. Like, what the heck are they talking about? It's untethered to anything that's even relevant. And it says, I want to note the contrast here, Judge, just for your honor. You know, when Trump was here, when Trump Jr. was here, and we were asking him questions, his memory was, quote, fleeting at the time, okay? He couldn't answer anything. And now he's on the stand, and it seems like he's pretty capable of remembering anything. Don't you agree with me, Judge? Colleen, typical. So Judge Engoron says, just pipe down, okay, over there. Colleen, relax, Faherty. I'm letting this document in, okay? I'll look like an idiot if I don't let this document in. I let all your documents in. I got to at least let them have one. Says, well, I think Mr. Robert eloquently explained why this is relevant, you know, in terms of the big picture. This is Judge Engoron. And he's giving the side eye to, you know, Greenfield. He's like, you like that, baby? What do you think of that answer? Doing good this morning. Good, happy Monday. So he says, the document says on the screen, thank you, finally, okay, here it is. Mr. Trump, it says, do you agree here? It says, for more than 4 decades, the Trump Organization has set new standards of excellence as it has expanded its interest in world-class hotels, luxury real estate, top-tier buildings, championship golf clubs, merchandise, entertainment, and event management. You see that? Yeah, I do. He says, well, you know, my grandfather, actually, he came out as the Horatio Alger story, which is, you know, typically a phrase, Don Jr. says, which is used to illustrate rags to riches. You know, the old pull yourself up by the bootstraps type of ethos. And the government, Andrew, he says, Your Honor, since we've gone back to the early 1900s, is there a waiver of the statute of limitations? And all the morons in the courtroom, yeah, funny joke there, bureaucrat, you know. So basically, remember that the defense is objecting over every time that they introduce actual evidence in 2011 because it's actually in violation of the statute of limitations, and they just keep overruling that. They don't care at all about the actual statute of limitations. So then you get Gooberface here, who is now going to be joking about statute of limitations while they literally violate the statute of limitations because Don Jr. is going back to the 1900s and referencing some old story. He's saying they waived statute of limitations, and the judge is just laughing about it. All right, so you get what's happening here. It's just kind of a joke. So the defense then, they say, all right, are you done laughing over there, morons? All right, so let me show you this slideshow of Fred and Donald Trump. And there's glossy PR photos of company properties, this beautiful slideshow of all the properties. Probably really fancy, right? This is kind of their pitch deck, think of it, right? It's their beautiful pitch deck of all the things. And the government is like, objection, it looks really good. He says, Your Honor, why is this relevant? Why are they showing us their slide deck? The judge says, well, why don't you pipe down over there, okay? You guys presented your case for 6 weeks. and the defense has time to mount their own case. So can you please stop objecting every 2 seconds? Judge Engoron's even like, gosh, this is ridiculous, which is wild. And I don't know what his Greenfield is thinking about this, but maybe maybe he's kind of feeling independent today or something. But Engoron stated that you guys have been going for 6 weeks. Can you let them ask 2 questions for crying out loud? Don Jr.'s up on the stand. He says, Your Honor, I promise I'll keep it under 6 weeks. They all laugh because it's actually funny. Now, Adams says, it continues on. Adams is the government. He says, so Engoron, Riley says, objection overruled. Go ahead. Talk about how great the Trump Organization was. It's a clown show. Well, I'll let you just talk. Go ahead and talk about how great Trump is. I don't care. I'm not listening to anything anyways. So it's like government, just sit down. I've already made my decisions. You don't need to object. I'm not listening. I don't care. So then they go through the slide deck, right? The pitch deck. They put the glossy slideshows on. From a room inside the plaza overlooking Central Park, looks beautiful. Don Jr. on Mar-a-Lago. He says, my father purchased that when it was one of the finest estates anywhere in the world. He likens it to like a castle. It's the finest estate, one of any in the entire world. And he gives us an overview of Mar-a-Lago. He says, it was built for Marjorie Meriwether Post, one of the first female industrialists anywhere in America. She entertained titans of industry, leaders from all over the world. And there's a photograph of Mar-a-Lago's majestic and cavernous atrium. It's displayed on the screen. Like, look at that. He says, you can't build that today. He's like, literally, you can't build that today. Like, that is not buildable. It doesn't exist. He says, they keep talking about $18 million appraisal. He says, you couldn't build that atrium for $18 million today. Now, the judge never appraised Mar-a-Lago at 18, says Adam. Now, displayed on the slideshow, a photograph of not yet President Trump is at the ribbon. He's cutting the ice rink in Central Park. Incredible. Dude's like a legend, right, in New York. He says, the Seven Springs Mansion was there in Westchester, New York. I brought my kids there. He says his father is literally an artist with real estate. He sees things that other people don't. He says that is his canvas where he creates, and he's a creative guy. So they walk us through the chronology of the Trump organization. They pull us back to 1995. They show this beautiful picture, 40 Wall Street. Slideshow displays the lobby, ex-Federal Reserve vaults, Trump family lawyer, moved into the tower. Don says, this is amazing. He says, this is a hotel condominium has never been done in luxury, never been done. Engoron says, all right, look, we got 5 minutes before our first break, all right? It's driving me nuts here, talking all this goodness about Trump. These buildings look really impressive. But anyways, I might call it a 10-minute warning because the witness talked so long, talking to Don Jr. Will you just quit yapping? And Trump's lawyer jumps back up, and Cliff Roberts says, hang on, Judge, don't you beat up my witness here. He doesn't talk nearly as long as other witnesses, and maybe referring to Trump. And Engoron says, well, that I'll buy. And Don Jr. says, well, I only got half the genes, so I only talk half as long as Dad. Then they take a break. And that's because they change questions. All right, and so then at some point, Don Jr. came out and actually made a statement during one of the breaks. And let's see if I have this one queued up. And right here I do. So this is during one of the breaks. Don Jr. comes out, makes a statement to the media. Here is what it sounded like with Alina Habba in the background.
Very large banks get paid back millions of dollars. There's no complaint from them, but an overzealous attorney general decides to try to break up a transaction. And the implications for future fraud, if perhaps they don't donate to her political campaign for any businesses operating in and around New York, are truly staggering, but that shouldn't surprise anyone based on everything that we've seen coming out of this attorney general, her statements both before having any knowledge, while running, and today. It's just a really sad state of affairs for New York. And again, where there is no actual person complaining other than the attorney general herself. It sets a precedent. Are insurance companies going to start suing hospital patients for listening to their doctors? Are they going to go after any transaction that doesn't contribute to their political campaigns? I would think that this would set a precedent to make it impossible for anyone to actually do business in or around New York City. But based on everything else I see in New York today, it doesn't seem like they care. Hopefully one day the people of this great city will realize what's going on. They'll realize the destructive practices here. They'll realize just how insane that is. And they'll be begging for guys like Donald Trump to come back to New York City to reshape the skyline as he's done for decades.
Any comment about your answer?
Yeah, obviously a little bit.
All right, you're listening.
So you got to keep doing it. That's the nature. That's the nature of all of this. But no, it's a rough day for myself and my family. I'm very close with, especially her grandson, and it's the day. But at this stage in our lives, it's just another day.
Will you be back tomorrow?
All right, so that is Don Jr. responding to not only the proceedings in court, but also to the death of the Trump family member, Aunt Marianne, passed away. And of course, we pray for her family and may she rest in peace. But that is what he's having to deal with, right? The family is under attack. There's no pause for any sense of decency in any of this stuff. And so their break was completed and they turned back. Now, morning recess is back and we're back. Donald Trump Jr. is on the stand. They say, tell us about what some of the things your father did in Florida. And he's, well, my dad's incredible. I mean, his vision was huge. He transformed the swampland in Florida into a golf course. And they now talk about Trump Tower and some other things. And it continues. Now, we jump over at Inner City Press and we fast forward to when Father became president. And here is what it says. Don Jr. is on the stand. He says, I want to ask you about the transition, right? We know all about your role in the Trump organization. But tell us about the transition into the presidency. Well, when my father became president, we dropped our international licensing. Probably a big mistake, though. People said we were still doing it, even though we dropped it. And we did it because, we didn't want a conflict of interest. And so we dropped the licensing, but people didn't care. They said, you're still licensing, and we got screwed anyway. So maybe we should have just kept done it. But we protected the projects that were underway. And so we did what we did. Now, how would you describe the structure of that now, of those different projects? How were those situated? He says, well, my brother and I would be in charge of it. And we ran it. Eric and I. That's it. Mr. Trump Jr., who is Mr. Weisselberg? Oh, Mr. Weisselberg, of course, we know him as the CFO for the Trump Organization. He was also prosecuted and convicted. Said he was with us for 50 years, man. He was our CFO for a long time. Very great guy. Until 2021. And Mr. Trump Jr., how was your relationship with Mr. Weisselberg throughout 2017? Oh, gosh, very positive. I mean, great guy. He was our accounting guy. Him, along with Mazars, loved those guys, went golfing all the time. Dude has a great putting game, blah, blah, blah. And Engoron says, can you slow down, Mr. Trump Jr.? Please speak more slowly. And he says, yeah, sure, happy to speak more slowly. I'd say I'm pleased to be here, except the Attorney General might sue me for perjury. Looks right at Tish. I'd say I'm pleased to be here, except Tishy might sue me for perjury. Smiles. Tishy's like, yeah. Alina Habba says, Your Honor, can we pause for a moment? My audio equipment is not working. And Engoron says, I don't care. Everything is relative. Right, can you hear him now? Great. Proceed. I don't care about your audio, Alina. She's like, what the heck, Judge? So they say, Mr. Trump, can you tell me about kind of the general services overview that you do at Trump Org? He says, well, we tend to be a full service type of organization. We own the project and we respond to the problems to keep our brand. We're totally vertically integrated. We don't like to outsource, blah, 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 blah. And the government jumps back up and says, objection, Your Honor. We don't think it's appropriate for him to be comparing himself to other businesses, and also lack of foundation. And what the heck is he talking about any of this for anyways? And Engoron says, yeah. That's the word I was looking for, foundation. I don't know what the heck you're talking about. So Trump's defense says, okay, well, we're moving on anyways. Mr. Trump Jr., tell me about how you would engage with other people who wanted to work with your organization. Well, Trump brand's a big brand. A lot of people want to work with us. And Trump was able to create this brand. And so other developers came to him. So they would, just be pounding the door down. Can you please put your name on our building and bring people over here? And so he would brand their projects for fees, and fairly significant fees actually, in order to get this stuff done. And they say, well, let's lay a foundation here so Judge Engoron doesn't flip out on us. What is a development, Mr. Trump? So they're going to lay some real serious foundation here. What is a development? Can you explain what a building is, Mr. Trump? Are there big trucks that go vroom vroom that build the steel girders? Oh, beep, boop, beep, boop, Oh, okay. You got it, Judge? Okay, is that enough foundation for you, idiot? Excuse me. All right. So Trump lawyer says, let's lay a foundation. What is a development? He says, building or buying or making changes. That's what we do. And let me give an example. He says, take Dubai, for example. They didn't really have a luxury market until 2006. They weren't doing anything there. But my father was a visionary. Well, what's the difference in risk between building something and licensing something? Is there a difference in risk? He says, yeah, there's a lot more risk in building something. Even in licensing, right? There's brand risk, but in building something, like if the project goes bad, it's a different thing. If licensing, it's a different risk. There's a brand risk other than a building risk because you've got the brand and whatever. So they say, I want to put this back on the screen. It's called the Trump story. And they put it up on the screen. Government, objection. Your Honor, these narratives are unfocused, and this, quote, Trump story, whatever they have here on this pitch deck, it's hearsay. And they say, Judge, this Attorney General Tish over there, warming up the chair, is trying to put the company out of business, okay? Our witnesses are going to go for weeks. We're not like going to just be done here. Are you kidding me? We're just getting started. So if they're objecting to us every 2 seconds, this is going to be a long trial. And the government says, Your Honor, this is ridiculous, okay? First of all, this witness is dishonest. Last week, his memory seemed to be fleeting. Now, this document is being used to guide him. And now they're showing it on the screen. He's walking. And the lawyer says, it's all photographs, Trump's defense. We thought of asking to do a site visit. You want to come and go look at it? But we thought that would be a little bit aggressive, unless you want to go to Scotland over there. Don Jr. says, yeah, maybe when it's a little bit warmer, okay? It's a little cold right now. Government's like, a party does not get to put its website on trial as an ad, okay? And the lawyer says, I'm trying to move it along. If you'd stop objecting, for crying out loud, I got like 2 slides left. Sit down and relax. And she says, well, it doesn't come into evidence. I don't want those photographs coming into evidence. And Trump's defense says, well, so photos are evidence though. The rest doesn't come in. That's fine, but I want the photos to come in. And Judge Engoron says, yes, that's my ruling. Photos come in, all of the language doesn't come in. How about that? And the lawyer, not happy. So Trump lawyer says, okay, look, Mr. Trump Jr., I want to talk about the history of the Trump Organization. He says, oh, I'd love to. My great-grandfather developed hotels in the Yukon for miners. My grandfather started working on job sites in Queens. He was asked to build a garage, and he ended up building a portfolio of apartments. Kind of crazy story. But my father then took it into Manhattan from Queens, and he literally changed the skylines. Government chimes back in again. Says, if we're in the 1900s, what about the statute of limitations? Laughter again. It's like, you already tried that joke. Hello, get a new line. They're so uncreative, these government bureaucrats. You literally did that like before the break. We didn't forget, okay? It's written in the tweet thread. You already tried that. Stupid statute of limitations joke, but they did it again. Okay. So they put up the photo. Who's in this photo, Don Jr.? He says, my grandfather and my dad. Now, from that hair, definitely before my birth, though. And what is this building? He says, well, that's the Grand Hyatt. It was a big job. Back in 1976, the government chimes in. Is he an expert in 1976 New York City, Judge? And Judge says he's putting on expert testimony, but I gave you, it sounds like he's trying to talk like an expert, but Mr. Trump's defense, but I gave you 6 weeks. And so Mr. Keese is going to talk about how I rule against them. And so I find this interesting. And so I guess I'll just let it go. Wild, right? I gave you 6 weeks. And if I rule against him, then Keese is going to talk about how I rule against them. And I find this interesting, so I guess I'll just let it go. Defense says, Your Honor, I'll keep it less than 6 weeks. We're not going to be here that long. Don Jr. says, I'll keep it less than 6 weeks. And so we continue on. So then there was the Trump Tower. We get to the Tiffany's air rights. It took here, my father maximized, maybe that was the same, maybe it's the same joke. We're just on a different thread. So maybe it's the same joke where our timelines are just off. So maybe I was a little bit too harsh on the government prosecutors for the same joke, but I don't know where we're at. Anyways, we're back. He says, then there was Trump Tower. We got Tiffany's air rights. Okay. It took other decades to figure out how to do it. My father maximized the far floor area ratio since I was 5 years old, but it seemed like this was pretty amazing. Other developers later told me what we did was unprecedented. Objection again. Hearsay as to what other developers told him. Okay, sustained. No other developers can come in on this. Don Jr., what is this? Another thing on the screen. The retail. It's genius. This was the West Side Rail Yards. It was an eyesore. He was going to build the tallest residential building as he later did from the UN, but the project changed. This project took 25 years. Another image. What's this? This is one of the lobbies where we were surrounded in that area by aging coops. This was new. My father was at the leading edge, putting gyms and amenities and otherwise saleable space. Now tell me about Mar-a-Lago. What about this atrium? Yeah, okay, so we do have a little bit more detail. So now we're at the atrium again. So we're sort of getting to the atrium from where we were with Klasfeld. So the joke was the same in both transcripts. So what about the atrium? It says, I took some umbrage for saying it, but you couldn't build an atrium for 18 million bucks. And this ballroom, it was built in the early 2000s for 15 million. And what about Central Park Rink? My father fixed it as our first City Works project. And what about the Plaza Hotel? My father took it over and then sold it again. How about Seven Springs? We're going to hear from Eric, your brother, later. But he says, my father's an artist. And do you sometimes leave some space unrented? He says, yeah, every project and market is different. And at one time, 40 Wall Street was one of the tallest buildings in the world. Now, Judge Engoron jumps in here. He says, you're using a banned word in my courtroom. Again, don't say it again. And try not to be so repetitive, says the judge. Don Jr.'s like, well, relax. He says, the Fed used the building to store gold. And again, we get another 5-minute warning. That's the same 5-minute warning. We're comparing transcripts now, just to be clear about that. They talk about some golf course stuff. And then they talk about Derek Jeter living at Trump Tower for a certain period of time. And then let's see if these threads continue. And it looks like we had kind of an end there. Let's see. Was that a lunch break? Yeah, my friends, I think that might have been it. Let's see what else Klasfeld had, because I think that was the end of the inner city press thread, which kind of ended unexpectedly. A little bit interesting. And let's see what else we've got. Scrolling down here on Klasfeld to get us caught back up. And I think that's about it. So I think that is the end of the trial thread. Yeah, this is interesting. So here's what we got. All right. We're back. They're going through their properties, right? One at a time. International Golf Links, similar, property here is very unique. Next property, Trump Golf Links at Ferry Point in the Bronx. Jack Nicklaus designed that course. The defense rolls tape on a promo video of the property. State objects again. Engoron says, okay, we'll let that in the background. Here's another one. Trump International Hotel. Incredible property on Pennsylvania Avenue. It was converted from the old post office. DC Hotel. It's sort of a great example of a public-private partnership. Asked about the company's future plans, Don Jr. wraps up his testimony pretty quickly. Says, well, it depends on whether we're soon into oblivion in the foreseeable future. I don't know if we're going to survive. That's up to these government bureaucrats. So direct examination ends on that note. Now, the state is up for cross-examination. Colleen's back up, Colleen Faherty. And she says, isn't it true, Eric, that the Waikiki Hotel is ditching the Trump brand? He's like, I don't know, or whatever. And the questioning's brief. That's it. No further questions from her. There's no redirect. Don Jr.'s testimony ends. And so that is pretty quick. That's why it ended so quickly on the other thread. Not much happening there, right? That's the end of Don Jr. Next witness up, Trump's lawyer calls Sherry Dillon. She's the next witness for the state. And she was already somebody who testified for the government as well. Judge Engoron says, hey, welcome back, Sherry. Feels like we're at a reunion again. Sherry, you promised to tell the truth, but yes, I do. Already been here before. Put her back on the stand. All right. They say, Miss Dillon, can you tell us about the purpose of some of these conservation easements here? Oh, sure. Yeah. I mean, this has been something that comes up a lot. And this has been an issue at the Seven Springs property in Trump, LA. Here's what happens is there's an appraisal, and the appraisal doesn't really take into the account the renown of the seller, right? So like they're just looking at property. And so think about it like this, like it would treat a property with Taylor Swift as the owner no differently than one that I own, right? Like there's clearly a difference. Like somebody says, I like this mansion because Elton John used to live here or something, right? Like, you know, those people. It's like Elton John. So like, okay, great. Okay, great. You know, what does that mean to you? Can you play the piano now? No. All right. So, you know, same type of thing here. You know, but it does add value to it. Like it actually adds value. Okay. It's Elton John's home for whatever reason. Taylor Swift's home, Donald Trump's home. It's like, yeah. So it's this type of appraisal that doesn't take into account that. And Engoron says every case has to have Taylor Swift in it somehow. It's like, good gosh, everywhere. Now even all the football moms are into her now. Great. So Klasfeld says, reporting from Klasfeld Reports, says, so the defense is now showing Sherry Dillon an email exchange. Miss Dillon, do you recognize this? Government objects. We don't want that coming in. Says, Your Honor, they can't use the objection over the email as a shield for them and then a sword against the state. So in other words, when the government tried to get it in, Trump objected, Trump's defense objected and kept it out. But now they're trying to get it in. And they're saying they can't use it to keep out, but then also to use as a sword. They take a break, and we're back. And they say Dillon is back on the stand. And there she's still looking at emails. You recognize this? Yeah. You recognize this? Yeah. This one comes from the Briarcliff approval. She looks at the document. Cushman Wakefield. They did the appraisal on the property. And they say, are these accurate? Does it look all good? Yeah, it is. No further questions. Sounds good. Do you approve it? Yeah, this is how it works. Yeah, great. Okay. No further questions. Government comes up. Miss Dillon, are you admitted to practice law in New York? No. Have you ever been admitted to practice law in New York? No. Couple more questions, and that's the testimony. No further questions, Your Honor. Any redirect? No, that's it. Testimony's over. All right, and so parties wrap on the day, scheduling matters, and that is it. And so, you know, semi-interesting trial day here. Thank you to Inner City Press and Klasfeld Reports for bringing us the reporting. Don Jr., of course, in the courtroom, explaining much of what we'd expect. Not much is going on here, right? This is just a regular business doing regular business things, not actually that interesting. What does make it interesting is the corrupt prosecutor, Tishy Latish, and her civil fraud prosecutors who are bringing in this case to strip Trump of $250 million and trying to destroy his business. And that the two elected people, Judge Engoron, elected Democrat, and Tishy Latish James, elected Democrat, both have a history of not liking Trump, and they're the ones running this circus show. So, my friends, we'll be here continuing to cover Trump's trial is still going on. His case in chief from the defense is just getting started. Hope you join us as we continue to unpack everything that's happening here. Thank you for subscribing. Thank you for checking out robertgovea.com to sign up for our daily newsletter, to get all the show reports, to access the mind map and more. And we'll look forward to seeing you on the next one. All right, my friends. Now, that's what's happening in New York. Not too far away, we've got Trump demanding his January 6th trial be televised. And so let's see what's happening here. Donald Trump is now demanding that his January 6th trial in Judge Chutkan's courtroom be televised. We would all like to see it. And why wouldn't the government want us to see this? I mean, if Trump is really the insurrectionist who almost wrecked American democracy, don't they think the public should see it? Shouldn't we be able to witness all of the actual evidence and the legitimacy on display? Well, of course, they don't want you to see their tyrannical nonsense. And so Jack Smith is objecting to this. The media already submitted a motion. We'll take a look at the docket. And he says, we don't want anything. We don't cameras, no audio, no live streaming. Get out of here. No carrier pigeons. Right? We want to bury this as far down as possible and just feed the little nuggets to the Washington Post, the New York Times, MSNBC, and then they can do what they want with the fake evidence on display in front of the American public. Now, Trump filed a motion saying everybody should be able to see this. Jack Smith says Trump is asking for special privileges, and we're going to get into all of it and more. But here was Trump's take on this. Pretty obvious, right? If you're being prosecuted and you're guilty, don't you not want people to see it? If you're innocent, don't you kind of want everybody to see it? Don't you want it all on full display so we can get the other side of the story? Here's Trump.
They said, sir, do you want a trial with or without cameras? Now, most people would say without. I say the opposite. I want this trial to be seen by everybody in the world.
That's right. Put it on display. Let us see it.
The prosecution wishes to continue this travesty in darkness, and I want sunlight. That's a nice way of saying it, isn't that pretty?
Yeah, sunlight.
I want sunlight. I want everything exposed to the public, including the election fraud, because this is all about election fraud, which took place in 2020 and the 2020 presidential election, so that such a thing can never happen again to our country. You know,
and he is right. We should all see it. And if it is so bad, then wouldn't that be the end of Trump? If Jack Smith really has all the evidence, wouldn't that be kind of the end of Trump's campaign if he can come out and prove it? Well, I don't think he can. That's part of the problem. That's why they want it all buried. This case that we're going to take a look at, these filings come from this. It's a media application for audio-visual access to the trial proceedings. This is the case of United States of America versus Donald Trump, coming out of Judge Chutkan and her courtroom out of the District of Columbia. And you can see Judge Tanya Sue Chutkan is here, and they're asking the court to grant them permission to get cameras in. And so to broadcast essentially what's happening. This is the original filing. Okay, so the media submitted the filing, the application back in October. There's been a slew of activity here. Bunch of lawyers are getting on the case. Reuters is here, right? Everybody's jumping in here. Joinder by Reuters. We got NBC Universal's here, and so on. And of course, the judge wants to hear from the parties. What does Jack Smith want? You're the prosecutor. What do you think? And Donald Trump, you're the defendant. What do you think? Well, let's take a look at exactly what is being filed. Now, the media submitted their request. Okay, they're like, hey, we got to see this stuff, right? These ratings are going to be gangbusters, man. So can we have access, please? Well, after all of their filings, we're going to fast forward through all of them. Just saying, First Amendment, right? Right to access of American people. It's a historic case, democracy, blah. Here is Jack Smith's response, 18 pages. He filed this November 3rd. We're going to see Trump's response and then Jack Smith's ultimately reply to Trump's response. Here is the highlights of what Jack Smith says. He says, Your Honor, you know, the media, they want permission to record and broadcast this trial involving Trump. But we know that local rule 53.1 has long held that there is no basis for broadcasting this stuff. So therefore, this court should deny the applications. Now, here's the factual background. Rule 53 says as follows. It prohibits broadcasting, right? And you can see it here. They're just going to go right to the rules. And they say in 1946, 1972, the rule, blah, 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 Chief Justice Rehnquist said, we don't want cameras in the courtroom. So they're referencing us back to a 1988 study. Has anything changed in the last 40 years? Since they did a camera in the courtroom study? Hello. The pilot program was recommended 91 to 1993, and courts have declined to modify these things. No significant changes have happened over the next 25 years, right? We go back from them to March 1996. Judicial Conference also came out in 2010. The Judicial Conference authorized another pilot project to see if maybe we could do this. And the pandemic brought about some changes to the broadcast policy. That's right, it did, along with some other policies like elections. In March 2020, pursuant to the VID, the Judicial Conference approved a temporary exception, it's exactly right, to permit judges to use teleconference technology to provide some access to judicial proceedings during the pandemic. So why can't we make an exception here? But on September 22nd, the Judicial Conference adopted a new broadcast policy that effectively returned to the status quo before the pandemic. Oh man, just a couple months ago. Isn't that convenient? They changed the rules again. No more pandemic again. No more broadcasting of anything. Now, although the policy permits a judge presiding over a civil or bankruptcy proceeding to approve remote audio access, They say here, the policy does not apply to criminal cases, and they stick to the same criminal code that does not allow criminal court proceedings to be broadcast, televised, or recorded, whatever. They say a grand jury charged Trump. In October, NBC filed a bunch of stuff along with a bunch of other people. But you get it, right? Here's the argument. Rule 53. They want permission. The rules say no. And to be honest, they're right. The rules do say no, right? And NBC and everybody just kind of has to eat it. Now, of course, if they really, really wanted this broadcast, don't you think that they would maybe apply for a COVID exception or something? They say NBC's claims don't apply. All of these other decisions means that there are no exceptions. And Rule 53 is constitutional. And, you know, the public be damned. You guys don't need to get access to this. We don't need to see what's happening when they're prosecuting the leading candidate for president, literally in the whole country. No, it's not a big deal. Prohibiting cameras in the courtroom passes constitutional muster because it promotes significant governmental interests. A content-neutral time, place, and manner restriction satisfies the First Amendment because it's narrowly tailored. So we can limit our rights, right? By the way, this is about not just, you know, courtroom shenanigans and antics. This is about our right as American citizens to hear from a candidate that we want to hear from. And they're limiting that. Right? Free association, free expression. It goes both ways. What good is somebody speaking if there's nobody to hear? You have all the free speech in the world. Throw you at the bottom of a well. Nobody can hear you. And it's not good. So we need to have that. But they say, wait, if we're going to limit our free speech, right, our First Amendment rights, our constitutional privileges, they say, this is Jack Smith writing, by the way, that the government can do that. It's neutral. It's unrelated to the content. It is compelling because the government has an interest in ensuring a fair trial. And if Trump has this broadcast, I guess that's not going to be fair. And say the broadcast rule promotes a substantial government interest, and there's nothing else we can do. And so the First Amendment is satisfied by our own government, like not showing a trial in public. We have live streaming technology. It's absolutely something that we can see here. But they say, no, we don't get access to it. Our government can prosecute one of the most important people in the governance of America, and they can do it all under dark of night, cover of night. They say here, they say the case law is not stale and pre-internet. Of course it is. They say the media coalition, they say we're relying on old cases, which was my point. And it says advances in technology do not diminish the government's significant interest in ensuring a fair trial. How does broadcasting this make it not fair? Okay, the jurors all can't watch it. They'll all be protected. And they say here, video not only airs on television, but it remains on the internet forever. It's exactly right. And when an image is captured on video, it's not just a fleeting image, but it exists. Okay, so hide the witnesses. That's fine. Cover up the witnesses. They say even their knowledge, their images will circulate on social media. And if they know that it's going to be broadcast, then their witnesses' testimony might be tempered, right? They may not be honest if they know it's going to be broadcast. And jurors may also feel intimidated. Let me just back up here. May temper a witness's initial testimony. Do you mean it's going to change from the rigged testimony that they're forcing? For example, we covered another story here about a special agent Capitol Police called David Lazarus that the Blaze and at TPC4 USA on X did an amazing report about, talking about Lazarus lying, saying he was in one location of the Capitol building when he was in a different location, not even in the Capitol building. And that would not have been found but for sleuthing by other people. So his testimony, theoretically, if we were watching it in real time, somebody may have been able to pinpoint that, right? And a liar may have been called out. But now that opportunity is not here. And so now liars can lie because nobody's going to call them out. And only the defense attorneys that are limited in terms of discovery, in terms of time and access. You know, think about this case. This is the January 6th case. There are 8 to 10 Washington monuments, like tens of millions of, over 10 million documents in this case. And just for context, Trump has about less than a year, I'd say. Less than a year to review 10 million pages of documents. And that volume of of discoverable material you find in cases like Walmart versus Visa, where it was like 7 million. Walmart versus Visa. Trump has 10 million. Walmart versus Visa took like 8 years, 7 years. Trump's taken like 9 months. Okay. It's crazy. And so all of that, like in that mess, Trump's defense, they don't have time. It's David versus 50 Goliaths in terms of resources. And so now, right, if they can silence this, that means the public can't call them out and demand that stuff be addressed. So they say if jurors know that the trials are going to be broadcast, they might feel intimidated. Well, then they should say something and not participate. And they should conceal their faces. Again, we don't need to see the jurors' faces. That's fine. And knowing that a trial is being broadcast can lead participants to grandstand. Well, it's fine too. Finally, so you're going to violate our free speech rights because you can't control the courtroom? Are you serious? Control your courtroom. And finally, whatever merits of Trump, they say, why Trump is uniquely appropriate, the same dangers are here. And so Rule 53 is appropriate. And so, Judge, do not let the media come in. This is Jack Smith, these pathetic little bullies who would rather, beat you up and jump you in the back of a dark alley than face you face to face like a man. They say here, the Judicial Conference, having studied the issue for decades, reaffirmed the policies in September 2023, like right before this decision was made, that its policy judgment is to prohibit audio. They don't even give us the audio. That's how pathetic. Or video broadcasting of criminal trials. This is what Jack Smith wants. And these loser deranged thugs over at the DOJ, James Pierce and others, signing off on this. They say, while applicants Trump are free to advocate their view to policymakers, this court should decline their invitation and deny all the media, not just Trump, but the media, from accessing it. It's like the media, it's like, aren't they irritated about this too? These are the same people. All these MSNBC people screeching at us every night. Trump, democracy, America, blah, 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 blah. Your own government, Jack Smith, your hero, so-called, is playing like a little weenie here. Doesn't even want this stuff displayed. If you're so tough, man, don't you want everybody to see? All right, here's what Trump said in response. So he said, Your Honor, shorter filing, 5 pages, submitted a short time after Jack Smith objected. Your Honor, before the court are 2 motions by the media requesting audio and visual recording as well as broadcasting of the potential trial and other proceedings. One motion is by a media coalition, the other by NBC Universal. Trump's defense says, for the first time in American history, an incumbent administration has charged its main leading electoral opponent with a criminal offense. That's Joe Biden. 234 years, never done this. Now he did it. And they're going to screech at us about breaking democratic norms. Okay. Now, aware that its charges are meritless, obviously, the prosecution through Jack Smith and the deranged thugs at the DOJ has sought to proceed in secret, forcing the nation and the world to rely on biased, secondhand accounts coming from the Biden administration and its media allies, all which is mostly fake. As a result, the citizens of our great country, that's you and me, are unable to review for themselves what the facts of this case show and how unfairly President Trump is being treated at the hands of his political opponent. As Trump has made clear from the outset, the prosecution has repeatedly denied him his fundamental constitutional rights, including the right to prepare for his trial and present a fulsome defense. Can't even read the discovery. And the prosecution through Jack Smith, Joe Biden, Merrick Garland, and Lisa Monaco, they wish to continue this travesty in darkness. Now, President Trump calls for sunlight. Every person in America and beyond should have the opportunity to study this case firsthand and watch as if there is a trial, and as if there is a trial, watch as President Trump exonerates himself of these baseless and politically motivated charges. The court should grant these motions without delay. Give access, bring in the cameras, let's live stream it. We'll be here covering the whole thing if they did it. But at every turn, says Trump's defense, at the prosecution's urging, this court has denied Trump his inalienable rights, including without limitation the following: the rights to a fair trial in a politically diverse venue. We're in D.C. where it's 80 plus Democrats. Due process, or how about a judge without the appearance of bias or prejudgment? When Judge Chutkan was already saying that Trump was free, right? Trump was free when she was sentencing other J6ers. I can't believe that some other man is out there. Trump's defense can't prepare for trial, and the right to speak freely and publicly about this case, he's been gagged. He can't even combat the prosecution's egregious lies. Now, Jack Smith, betraying his solemn obligation as a prosecutor, they are sworn to be sure that justice shall be done. But instead, no. These people have thought and sought the inexcusable constitutional violations as part of a coordinated effort to undermine Trump's candidacy as he faces and leads President Biden. Now, despite systematic prosecutorial misconduct, this court has not acted to ensure or to protect Trump's constitutional rights. And so the defense continues. They say, Your Honor, Chutkan, there is a high risk that proceeding behind closed doors under these circumstances would serve to further undermine confidence in the United States justice system while continuing to prejudice Trump's rights. For good reason. Political trials, quote, have virtually no defenders. They are reviled as a corruption of the judicial process and a betrayal of liberal principles. Show trials, they say, tell more about the power of a state than about its concern for the decent administration of justice, with every citizen receiving the same kind of justice. And they say where a judicial proceeding takes place without the traditional notions of due process, in a transparently partisan mission to defeat a political opponent ahead of an election that the administration is likely to lose, value can be gained from televised broadcasts. We don't have traditional norms here, so adding TV will add protection. They say the public exposure will ensure that all of us can see how the Biden administration is unlawfully and unconstitutionally attempting to eliminate its leading opponent. Make no mistake, many of Trump's constitutional rights have been denied in this case. Exactly right. Here we go. Despite dumping nearly 13 million pages of documents on Trump's defense counsel, along with thousands of hours of video and audio content, which I can't even explain how much that is. We got trials in March, by the way. Just do the math on that. All right. Trials in March, 13 pages. We've got 5 months, 13 million pages. 5 months, 2 million pages a month, and then change. Right. 2 million pages a month and change. That's every lawyer doing that. And watching the video and listening to the audio. Every lawyer. It's not possible. Okay. It's literally not possible. It's reprehensible is what it is. But the judge did it. The prosecution sought a near immediate trial, no extensions. They wanted it to begin the same day as an evidentiary hearing in a separate criminal case, also brought by Jack Smith. So they also are trying to squeeze Trump's defense, so there's no time to adequately interview witnesses and even respond to charges. It's like when we were watching the communist prosecutions, in history, this is exactly what they would do. Right? You get a lawyer technically, but we're going to give them so much paperwork, man, and they're going to have like one printer and one ream of paper. All right? So you're going to have a lawyer, but not really. The prosecution has also stonewalled Trump's reasonable request for relevant discovery and exculpatory material. So also demanding early and unfair notice of Trump's defenses. Are you going to use advice of counsel defense or not? We're going to gag your free speech. We're going to make sure that you don't even have time to prepare. All because they want to win an unjust conviction. Now, even though those deranged thugs over there, they claim otherwise, their actions speak far louder than its words. Here, as political opposition brings charges shattering 234 years of historical precedent, breaking all of the traditional norms of democracy, the prosecutors and the court should go above and beyond to ensure fairness and due process. But unfortunately, at every step of the way, the court has allowed these attacks on Trump's constitutional rights to continue, placing the interests of the political opposition above those and the precious protection that American patriots have fought and died for since our inception as a country. Now, as such, this case has all the unfortunate badges of a trial in an authoritarian regime, lacking legitimacy, lacking due process. The public deserves to know about this travesty of justice and judge it for themselves. Sunlight is the only disinfectant now available to restore justice to this proceeding and to ensure the public's confidence in our justice system is not irrevocably destroyed. In sum, President Trump absolutely agrees and, in fact, demands that these proceedings should be fully televised so that the American public can see firsthand that this case, just like others, is nothing more than a dreamt-up, unconstitutional charade that should never be allowed to happen again. And furthermore, President Trump is entitled to present his positions in this case to the American public, including his sacred obligation as president to investigate and address fraud and other irregularities in 2020. Therefore, Judge Chutkan, this court should grant the motion and allow the media companies to broadcast the proceedings of this matter in order to ensure that the American public can see the bare truth of this case, witness the Biden administration's wrongful acts, and hear all the evidence regarding an election that President Trump believes was rigged and stolen. Signed by your friends, November 10th, John Lauro and Todd Blanche, Trump's lawyers. Man, good stuff here. And this was the response, siding with the media. Donald Trump agrees with the media because they're right. This should be public and open for all of us to see. And Jack Smith doesn't want it open because he knows we would see the truth. Jack Smith filed this reply. Okay, so Trump submitted his agreement. And here's what Jack Smith says, and he's not happy about it. Your Honor, we already said that we objected to the media. And on November 10th, Trump responded that he wants this to be broadcast. But Donald Trump does not cite a single rule or a case in support of his position. Why? Because there are none. Well, that's true because you've never indicted a former president before multiple times and said that this was an insurrection. Like this is all new, right? There isn't going to be case precedent here, guys. That's the point. Now, instead, decrying the alleged unfairness of the unequivocal, they say unequivocal, and constitutionally sound broadcast prohibition that has governed federal criminal trials for decades. But they say Trump's response is simply a transparent effort to demand special treatment. He wants to try this case in the courtroom of public opinion, which is his right. He's running for president. We also have the First Amendment. Do we not have a right to hear about it? And turn his trial into a media event, which it is a public, it's a political event. Literally, it's a criminal trial, but it's also a political event because he's running for president and he's being prosecuted by his political opponent, which is why you don't do that stuff. So they say the court should reject this distraction. And now they say, although Trump pays lip service to proceedings where everybody gets special treatment, they say Trump wants special treatment. He offers no case law or legal precedent to support his case, obviously. And his purported interest in sunlight does not cure the defect. He wants his trial to be different than every other criminal defendant. He ignores that high-profile criminal trials have long denied media coverage. And this has remained true everywhere. January 6 case trials, and so on. He says, but the comprehensive, often minute-by-minute public reporting provides further evidence that we don't need sunlight. So they say that we're perfectly good with the New York Times, Washington Post reporters in there just tweeting away or live streaming away. We're very happy, of course, with our ex-transcript friends, people like Matthew Russell Lee at Inner City Press, people like Klasfeld and others on X at Klasfeld Reports and at Inner City Press. But we would like, as great as we think they are, we would like to see the video and the audio. That'd be a little bit more information because you can only tweet so much so quickly. So they say these rules apply to everybody and Trump is going to be treated exactly like everyone else, just like you said, Trump, and just like every other criminal defendant. Trump may elect to proceed to trial. He may put on his defense, and he's going to have the same due process that every other defendant is going to have. Yeah, right. Now, he may elect to craft court filings, and he may want to gather media coverage, but neither he nor other criminal defendants is free to break the rules. And so Trump peppers his response with various references to fairness, right? These prosecutors really hate when you say that they're not fair. Like they wake up every morning, they're like, no, I'm a fair person. I do just things. I'm helping society. They're kind of mental. But what he actually seeks is to defy a uniform and long-standing broadcast prohibition to keep trials orderly. Well, how come all the state courts can broadcast stuff and it doesn't turn into a disorderly chaos, huh? Now, he desires instead to create a carnival atmosphere, which you guys have already created, from which he hopes to profit by distracting, like many fraud defendants try to do, from the charges against him. Now, this scenario is not hypothetical. The court has already observed in other trials that the defendant and his lawyers will, if permitted, design their in-court statements to wage a public relations campaign, which they are free to do. We have a First Amendment in this country, and it doesn't get wiped out because they're going to lose a PR campaign. If they were so legitimate and so just, they wouldn't have to hide anything. They would just play it for us. And Trump could say whatever he wanted. This is a witch hunt. This is rigged. And you would just say, no, it's not. Here's all the evidence is right here. Okay, that's all. It's right there. It's literally right there. But in Trump's civil fraud trial, he keeps using testimony to condemn a political witch hunt, prompting the judge to admonish him. This is not a political rally. So they're referencing Judge Engoron, one of the most insane cases we've ever witnessed here. Now, although Trump proclaims that his goal is for the American public to watch this, he has made consistently clear that he doesn't want a trial to happen at all. Well, that's also true, because you should dismiss the case. But if it goes to trial, then we should see it. If they sought sunlight as he claims, he should welcome the opportunity to have a trial, which maybe we will. I think we will have a trial, by the way. So we'll get there. And so okay, if we do have a trial, then this person, James, if we do have a trial, James, then would you agree that we could broadcast it? So he should welcome the opportunity to put its proof at trial. Can we also broadcast it? Instead, he shows he's going to continue to avoid answering for his criminal conduct, and he's going to publicly grandstand on the court's docket. And so this court should deny Trump's demand. How insulting that he's demanding anything of you, Judge. And he's not above the rules. He's not above the law, and it should avoid the spectacle and the risks of witness intimidation that the longstanding rules against broadcasting are designed to avoid. And so therefore, these little whiners they say this, the media and the access should be denied. Wow, that's incredible. Yeah, a lot of other courtrooms broadcast trials and not everything melts down, right? We've covered many of them here. What happened with the Kyle Rittenhouse case? That was a monster case. Did anything go awry there? Well, maybe the lefties didn't get the conviction they wanted. Maybe that's why they don't like the broadcasting. So we've seen other cases. We've covered the Derek Chauvin case, the George Floyd case, right? That was a monster national trial. All of it was televised. Did everything go askew? No, it's fine. But what's happening here is Jack Smith and the deranged thugs at the DOJ, they want to silence their opponents because they know their case is garbage and they don't want anybody else to know that as well. Now, I am 99% sure that Judge Chutkan is going to come out and deny this, and we're not going to get to see it broadcast, and it is a real travesty. That being said, we're going to do everything that we can here to get the transcripts in real time and to cover as much of them in real time as we can, because we are not going to let these little maniacs bury this and sweep this thing under the rug. We're going to be here continuing to cover it, my friends. I hope you join us as we do. Thank you for visiting robertgovea.com to sign up for our daily newsletter. Get all these segments delivered to your inbox every day. You can also visit the website to read the reports. All the segments are translated into summations, and so you can check those out. And we look forward to seeing you on the next one. All right, my friends. Now, we got one final segment on the day. And we're going over to Georgia now. And this is an interesting one involving this guy who you're familiar with, known as Brad Raffensperger, the phone call guy from Georgia. Now, but this is not Big Fanny. We're actually going a little bit further back in time. A federal judge finds that there are major deficiencies in Georgia and their election systems. You're kidding me. Now, you might think this is a case from 2020, but no, it actually goes back further than that. 2017 is when this was originally filed, and it's called Curling versus Raffensperger, and it's a monster one because it comes from this judge, a federal district judge. Her name is Judge Amy Totenberg. She was appointed by Barack Obama, and she's been on the bench for quite some time. And this case originated after some election shenanigans some time ago. And I just want to point out, it's taken 6 years to get to this conclusion. But if there were problems in 2017 and 2018, and they were massive, and the judge found out about them, and they told us that 2020 was all perfect and sophisticated. Never mind the water main breaks when they were counting absentee ballots at the State Farm Arena. But this is the order. This is the opinion. And what this judge has found is that there were so many problems in Georgia that this case is going to go forward to a trial. And so let me just give you the background on what the docket looks like so you can see how much litigation went into this. And I think this is important because they told us in 2020, all of your court cases, they never found any fraud. They never found any problems, blah, blah, blah. Well, look how long it took to uncover this stuff. Filed August 8th, 2017, and it's just litigation for literal years, okay? Over 6 years, we have been seeing this case unfold. That's all the first year. Denying, okay, all of it. So my point is, in 2020, when we have 6 months to bring an election case, or less than that, really, we've got like 2 months from November to January to make our claim, you're not going to find anything. This case has been going on for 6 years, and now it's getting very close to proceeding towards a trial. And so let's go into the opinion and get right to it. It's a big one, 135 pages. So we're going to hit the highlights and see what we can unpack here. But this was filed recently, November 10th, 2023. It's a big one. It's an opinion and an order. And as I mentioned, it's Judge Amy Totenberg who signs off on this thing down at the very bottom, right? This is a federal judge out of Georgia, which is a big deal, right? It's being a kind of high-level judge that we're dealing with here. And this is what she writes in summation. Now, we're going to go through the highlights because there is a lot. But starting at the top, she tells us, filed out of the Northern District of Georgia in the Atlanta Division, were in the same wheelhouse as Big Fanny and the RICO case. Here's what Judge Totenberg says. Elections are contentious matters. So too are election cases. But the central issue in this case is not about partisan advantage, nor is it about how the winner of any specific election should be selected, or why a group of particular voters or candidates have allegedly been favored, and it does not involve allegations of fraud, right? None of that stuff, common issues. Instead, okay, it's not about who won or whatever, particular group of voters. We're not jockeying who's first, second, third, whatever. Instead, this case focuses on Georgia's statewide electronic voting system. Footnote 1. Well, it must be similar systems that we used in 2020, huh? As currently designed and implemented, they say it suffers from major cybersecurity deficiencies that unconstitutionally burden plaintiffs' First and 14th Amendment rights and the capacity to case effective votes that are accurately counted. Weird. You're kidding. I thought they told us that all of these election systems were perfect. Now, this is what they say about Georgia. Since its inception, this election case has gone through multiple stages of evolution. The people bringing the lawsuit, who we should call out here as Donna Curling suing Brad Raffensperger, the same guy from 2020, they say plaintiffs have raised challenges to both the original and the critically outdated direct recording electronic voting system called the DRE. And guess what? That's the old one. But they also call problems about the current Dominion ballot marketing device, the BMD. And the BMD replaced the DRE several years ago into the case, starting in 2020. Oh my goodness, you're kidding me. Weird. This is a federal judge writing this. Plaintiffs have raised challenges to both the original DRE and the current BMD system that replaced the DRE system. Years into the case, starting in 2020, they made the swap. A plethora of new factual and legal developments emerged along the way, and they were topped off by the breach of the Coffee County election system in early 21. Now, this breach and the copying of shared election system software and voting data to actors and entities inside and outside the state, and these might be some Trump people, by the way, right? Like some of these people have been indicted. So they might say that this breach was conducted by Sidney Powell, for example. Like, we'll see. Like, we got to pause on that. Now, as well as through the internet, it says it bears serious ramifications for the future vulnerability of the state's election system as a whole. They say plaintiffs initially discovered this breach in 2021 and thereafter in 2022 conducted a series of depositions of individuals, some of whom were indicted in the pending RICO criminal case in Fulton County and Superior Court. And they say this case's broad evidentiary scope can be daunting. To assist the reader and the review of the order, the court has started by first providing a cast of many of the key individuals who in the last few years have played a role in this case, as well as a glossary of terms. Okay, so this is like monstrous. 2021, 2018, the old DRE, the new Dominion systems, BMDs, okay, all of it is pretty bad. And it's a cast of people who played a role. And then we're going to process information. They say, provide information necessary to give context for a range of topics, including the following. They say, the use of computerized electronic voting systems in Georgia and the history of cybersecurity raised by the courts, reliability. All right, let's fast forward. They say review of this order takes patience. Sorry, Judge, I fast forwarded. I don't have it. Ultimately, the court concludes. So she's telling us what she did. This is what I did. Then I looked at their defense. And they say here, ultimately, the court concludes that there are material facts in dispute presented in the record that preclude its grant of the state's motion for summary judgment. Okay, so that means Brad Raffensperger says, Your Honor, there's no case here. Okay, we want this ruled in our favor. And even if you accepted everything that Donna told you is true, she's still going to lose. And so find in our favor with summary judgment. Judge said, no, sorry. There's too much here. The facts of the case are at issue, and I am denying your summary judgment claim. The court will resolve these material factual disputes and related issues at a bench trial. Woo! We're scheduled for trial January 9th, 2024. So mark your calendars, my friends. Or don't, and we'll do it for you. That said, the court finds that several distinct requests for the relief are largely outside of the scope of this case. And so they say, to be clear from the start, the judge admits the court does not have the legal authority to grant the broadest relief that Curling, the plaintiffs, are requesting, saying the state's legislature has power to do some of this. But even if they prevail on their substantive claims, we can't order Georgia to pass legislation, creating a paper ballot system, or we can't judicially impose a statewide paper ballot system as injunctive relief. Like, we can't give you that. So the only thing we can do is just identify these constitutional deficiencies and then turn it over to the legislature from there. Now they tell us, here are the claims. If the plaintiffs carry a heavy burden to establish a constitutional violation to the BMD, the Dominion system, here they've got to prove whether in the manner in which they implemented the system, like, does the implementation of the Dominion system, does it impose serious security voting risks? Does it burden the voting rights or otherwise? And if plaintiffs prevail at trial, what can we do? Can we use them without QR codes? Is there a broader scope of election audits? Can we do better things with accuracy? Are there other cybersecurity measures? All of the things. She says, look, now I've told everybody in this case, okay, I'm a judge. I can only do so much. This is a huge problem, but it is in the public interest to seriously engage in the hard work of attempting to reach a consensual resolution regarding the voting system remedial measures that the state could implement coming soon. The court can't wave a magic wand here, but reasonable, timely discussion might make the legislature do something, but I can't make them do anything. So for now, trial is starting in January 7th, 2023 is when the trial will start. And that will be a bench trial. So we're looking forward to that. Anyways, we continue on. She says, now the legal standard for summary judgment, we're going to fast forward through all of that. Here are the cast of characters. Again, this is pretty big. The plaintiffs, who are the people that are suing? The Curling plaintiffs includes Donna, and Jeffrey. Shout out. The coalition plaintiffs are also listed here, Marilyn Marks and others. We've got the state defendants, Fulton County defendants, and then the Secretary of State's office. Okay, that's Brad Raffensperger and company. We've got a bunch of expert witnesses here. Plaintiff experts, so these are for Curling's people, Dr. Philip Stark, Dr. Alex Halderman, and on and on. We've got defense experts, Juan Gilbert, data systems breach in Coffee County, Kathy Laham, Scott Hall, and others. And here's the list. Then we've got a glossary of the terms. Now, again, we're going to fast forward through most of this, but it looks like image cast. Okay, we spent time on this before when we were covering the 2020 stuff. EMS, election management stuff, QR codes, we know what those are, auditing, and so on. But here is the relevant background, now that we've got the terms and the parties identified. The judge says, regarding Georgia, this election security case has been a long roller coaster ride with many twists and turns. The court provides the background and the context necessary to understand what's happening. But in doing this, we're not making any factual findings. We're just considering it. So with that framing in mind, we're going to talk about a couple things. First, we're going to talk about the vulnerabilities and the issues raised regarding the prior DRE system, okay, the old system. Now, while this system is no longer in operation, many of the very same concerns persist under the new BMD system. Out with the old, in with the new. The new system will fix everything. No, you have corrupt people. That's the problem. The software is not going to fix the corrupt people. So after addressing, like the old system is replaced with Dominion, judge says, still problems. Now, after addressing the litigation and findings about the old DRE system, we're then going to talk about the current system. Then we're going to outline some challenges to the Constitution. Then we're going to review concerns about 2020. And then we're going to talk about post-2020 stuff moving forward. There's a lot. Now, quickly, the vulnerabilities of the prior system, because we want to see what the problem was. In the original complaint, they say that the system was compromised, not been properly examined, tested, not been tested, and it was vulnerable to outside manipulation. They filed the lawsuit, Curling's, right back in 2017. The case was initially filed in Fulton County on July 3rd. So they filed it in Fulton County Court, and then it was removed to federal court, which is where we're at now. The original complaint said that Georgia used the DRE system. It was burdening their right to vote because it wasn't accurate. Then in the summer of 2018, they filed motions for preliminary injunctions. They're saying, hey, the midterms are coming up, and they brought in some experts. This guy came in, Logan Lamb. He says, you know, this guy, he says, this is kind of weird. Plaintiff presented evidence that in August 2016, a professional cybersecurity expert called Logan, he discovered, weird, he could access via the CES public website multiple gigabytes of election data. Like, no, it's just browsing around on the Googles, you know. Thousands of files with private elector information tucked inside, home addresses, birth dates, and more. Just gigabytes, spreadsheets, everybody. In addition, he says, I got access, again, via the internet, just logged in. I got the election management database for at least 15 counties. Databases that I could create ballot definitions on, program memory cards, tally, store. Remember, the judge is not finding this is true, but this is evidence that has influenced the judge's opinion. And she's putting it in an order. So like she found this dude kind of credible enough to put him in here, as well as passwords that polling place supervisors used to administer. Lamb immediately alerted the election director, but despite this notification, they didn't do anything about it. It's Georgia. Man. Does anybody else know what you can do? No? Okay, well, that's probably good. Months later, in February, one of Lamb's cybersecurity colleagues discovered he was able to repeat what Lamb had done and got the same key election data. Weird. On March 1st, Grayson notified another colleague and someone else notified, and days later, the FBI was alerted and they took temporary possession of the CES server. Data's all already gone. It's all already out there, right? China's got it. Everybody's got it. A few months after that, on July 7th, 4 days after this lawsuit was originally filed, all data on the hard drives was destroyed. Elections.kennesaw.edu was destroyed. They deleted it all. Now, a day after this action was removed to court, after they took this from Fulton County to district court, all the data on the secondary server, which contained similar information, was also destroyed. That's weird. Who are these people destroying evidence? Are they Hillary Clinton? Were those in a basement somewhere? Now, after these events, the Secretary of State, they shut down the CES. Like, oops, not good. Only CES members transferred to the state was Michael Barnes and someone else. Barnes had a degree in public information training and so on. Now, they held a hearing in court, and the court found that they should, like the plaintiffs, yeah, you guys have shown that the DRE system was bad. Yeah, the high risk of alteration of ballots that could impact our votes, but the court declined to grant injunctive relief because the defendants were warned. It said that further delay by the state in remediating the outdated technology would be intolerable. So then in spring of 2019, they file another set of suits. They say, we need paper ballots. This is ridiculous. This is all rigged. They sought to require Raffensperger and the government to address the ongoing issues riddled with data reliability problems. And after a hearing, the court granted in part their injunction. They said in 2019, the court found that plaintiffs had presented a catalog of pervasive voting problems arising from 2017 to 2018 that had compounded and expanded the evidence established in 2018. The evidence at that time demonstrated that Georgia's election system burdened the plaintiffs' right to cast secure, reliable votes. You have a right to vote securely, not a right to go in, vote, and have some bureaucrat dump it into a shredder. Those pervasive voting problems included, among other things, the lack of a paper ballot trail, outdated operating systems, bad software, further development about breaches at servers that they just delete, and so on. Now, the court is going to give us an overview of all of these problems. Lack of a paper trail. And we're going to see if these apply to the new system, so we'll go through these clean. But first, the court recognized there was no paper voting trail in the old system. You couldn't count where they came from and track it. They also had outdated operating systems. These servers were running on Windows XP 2000. Oh, gosh. Slow and ineffective responses to data breaches. Next, the court reviewed the evidence about data mismanagement, the record destruction events as well. Even though Mr. Lamb, this expert, made exhaustive efforts to try to bring this to somebody's attention, they didn't do anything. Everything was grossly out of date, the essential Windows software. Nobody cares. They're like, what are you kidding me? It's working perfectly from our end. The expanded record also revealed the extent to which the director at the time was aware. He knew all about it. In fact, the staff had confirmed these threats. And the supplemented record shows the extensive efforts that were expended to inspire action. Okay, like a ton of people were warning them. It was only after Lamb and his cybersecurity colleague called Grayson talked to somebody at KSU. Green, after confirming the exposure, calls this guy, Stephen Gay. Gay says the security team, moreover, like everybody goes into it. One of the files that was problematic, 5.7 million records with personally identifying information, and these guys can't figure out how to secure it. It's your government for you. Now, a detailed incident report was identifying the seriousness of all of this, but there was no evidence that measures were taken to assess the integrity of the election data that was ultimately transferred to the server. So they don't even know what's in it. There were problems with the voter registration database. In addition, the court found in 2019 that these plaintiffs here presented significant evidence of vulnerabilities in the voter registration database. Again, outdated software. Again, no remedial action to solve the problem. They said, we did do some remedial action. We got this company called Fortalise Solutions. They're a forensic company, but it was outside of their contract to focus on election division or GEMS data. So they actually didn't really bring them in to do much of anything. So based on all this evidence, as the court stated, the state, quote, had stood by for far too long in failing to address these vulnerabilities. But even so, after considering all of the evidence, the court found that the weighed against granting a request for an order requiring a better system. They still said, well, what can we do? So they're trying to fix everything, and so we can't grant you, like the judge is not going to grant the plaintiffs the right to just reform everything. Now, Georgia then transitioned. Georgia transitions from the DRE to the new Dominion. Now, in the middle of this litigation, the Secretary of State office, right, they're all under pressure. They know all their systems are super problematic. They say, we better get a new system. Plus, Trump's running again. In April 2019, the Georgia State Legislature enacted a new bill. It required the secretary to replace the DRE system. HB 316 requires the state to switch to a new voting system that uses electronic ballot markers. It also required audits. Additionally, at the time it was enacted, it contained additional provisions requiring the Secretary of State to select at least one county to perform a risk-limiting audit by December 31st. Have to launch a pilot program. It was later removed from the statute, and other provisions were weakened in 2023. Yeah, of course they are. All the provisions are weakened because they tightened it up and then they weaned it back down. So they say the Secretary of State in July issued a notice to award the new voting systems in the run-up to 2020 to Dominion. Now, how does this work? The Dominion Democracy Suite includes the following components: a BMD, Dominion EMS software, blah, blah, blah. Here's the process. Now, while the scanners count the in-person votes based on QR codes, in the event of a recount, human readable text governs instead of the QR codes. The BMD system was used for the first time on a statewide basis June 9th for the presidential primaries, and currently it's being used. Now, they just amended their complaints, okay? So they just swapped it out. The same plaintiffs are still here. They're complaining about DRE when this lawsuit starts years ago, 6 years ago. They switch the system and they say, okay, fine, it doesn't matter. Just put in Dominion. It's the same problems. They literally amended their complaints to just challenge BMD. 3 substantive challenges, much the same. They say that the BMD system also violates the same constitutional rights, and the government moved to dismiss. Then we filed another round of motions. But here are the concerns. As discussed above, there are concerns about QR code vulnerabilities, that those might be subject to alteration. As discussed, the BMDs generate paper printouts that include both the voter's selections and a QR code. So the QR code is supposed to be an encoding, I think. Let's see what it says. The printout is then fed into a separate ballot scanner that records the information from the QR code, not from the list of the voter's selections. So you think you vote for Trump right here, right? You go voting for Trump and not for Biden. And you vote for, Republican senator here, not for this person here. And you say, okay, great. And then what you do is the machine, you push all the buttons, the machine spits that out. And on the left, it has your results. And you say, oh, perfect. That's exactly what I voted for. But over here, you get this QR code, right? And it says, it looks like a QR code. And it's all, discombobulated. And it says, the QR code, it says that this matches this, right? That this and this match each other, that they're the same thing. But what if they're not? Okay, what if this is not true? What if this QR code has just been programmed, because we can't read it. It's supposed to be the same thing, but this says Biden, 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 right? Or Warnock, Warnock, Warnock. And we think we're voting for Trump, but we're not. We're actually voting for Biden. The scanner saves the QR code information to removable flash drives, and plaintiffs say this system is problematic. The machines that generated the printouts were vulnerable to hacking, and they could result in the alteration of either the human readable text or the QR codes. Plaintiffs could not verify whether the QR codes actually match their results. The curling plaintiff submitted a motion. Dr. Alex Halderman made this argument. He said, easy. Malicious actors could easily infiltrate the voting system. Various cyber attacks, a lot of stuff could be deleted, added. The court noted that the findings were consistent with a broad consensus among cybersecurity experts that BMD systems are susceptible to malware. And the same experts that agreed that these vulnerabilities take on greater significance in these systems because it relies on unauditable QR codes for counting the votes, okay? Georgia relies on unauditable QR codes. They cannot be read or verified before the voters. So they say they're raising concerns about the ability to audit these results. Specifically, selections contained within the QR codes did not match the selections that appear to be human readable. They say that the plaintiffs argue the audits would not necessarily remediate these issues because most voters don't review this stuff. And they presented a bunch of other things when only 6.5% of voters even notice these things. Now, there's also concerns about software upgrades. They say here, Dominion software had an upgrade that was available. And in its order, the court remarked it could not fathom why the state would not at least be moving forward towards the consideration of the option. So this is interesting. They say that Dominion upgrade was available that would enable the scanners to capture the voter's selection as reflected in the human readable text of the printouts. So in other words, when you submit your ballot, so what happens is you go into one machine, you pick your options, you say, okay, Trump, Trump, right. It prints the ballot out. You take that over to the counter and then you scan it and then it counts the votes. So like you vote and then collect. So they could have just turned off the QR code, essentially, right? We don't really need that. We'll just read these. But they said, no, we're going to not read these specifically, and we're only going to read these. Why is that? Because they could encode something in the QR code that's not on the face, and it looks like you're voting for something that you're not. So instead, the QR codes says at the hearing, all they could have done is just updated the system. And the court says, I don't understand at all why you would not at least consider that option. Like, well, we just like the QR codes. Now, after the hearing, the court found that the evidence before it revealed serious system security vulnerability and operational issues that adversely impacted the right to cast an effective vote that is accurately counted, our right. The court said the substantial risks and the long-run threats posed by Georgia's BMD system, that's the new Dominion system, at least as currently configured and implemented, are evident. But nevertheless, the court said, while it recognizes the plaintiff's strong interest, the state has to manage a fast-approaching election. The challenges are broad, and so we're not going to grant broad injunctive relief, right? There's an election coming up. We're going to let them do the best they can. But something happened after 2020. The parties built a considerable evidentiary record in the years leading up to 2020. That record has substantially grown in the nearly 3 years since 2020. The most significant new evidence related to this, are more assertions about the Dominion BMD system vulnerability. It includes Dr. Halderman's 2021 report, a CISA report, Fortalice's 2021 technical report, and the 2021 voting systems breed in Coffee County, saying it's still a problem. In this case, Dr. Halderman in July 21, he identified 7 core vulnerabilities with Dominion. A lot. One, he expounded upon his prior testimony and he identified additional vulnerabilities. He spent multiple weeks studying the voting equipment. He tested them for vulnerabilities. He developed proof of concept attacks, and Dr. Halderman contended, he said, could be used by malicious actors. Here are the findings of his reports. And this is in 2021, July 1st, 2021, submitted a detailed, lengthy report. He says, the principal findings, he determines that the BMD and related voting equipment suffered from, quote, critical vulnerabilities that could be exploited to subvert all of their security mechanisms. Wow, that's nice. Now, in particular, he identified 7 primary vulnerabilities as follows. 1, attackers can alter the QR codes on printed ballots to modify the voter selections. And we were covering this right after the elections. What if they didn't match? Anyone with brief physical access to the BMD machines can install malware onto the machines. Attackers can forge or manipulate the smart cards that the BMD uses to authenticate anybody who interacts with the machine. Attackers can execute arbitrary code with supervisory privileges and then spread malware across a county or state. They access one device and execute arbitrary code with supervisory privileges and spread malware to all BMDs across a county or a state. Attackers can alter the BMD audit logs. So once they've done the hacking, they just change the log. No, nothing happened here. Attackers with brief access to a single BMD or a single poll worker card and a PIN, they can obtain county-wide cryptographic keys, which are used for authentication and to protect election results on scanner memory cards. A dishonest election worker with just brief access to the ICP scanner memory card could determine how individual voters voted. Just 7 from one guy. Now, Halderman expounds on the specific nature of these vulnerabilities. He said the first identified vulnerability, the QR code thing, says attackers could easily do this, make alterations difficult to detect. And as a second example, related to all of the other vulnerabilities, he explains that attackers could install malware on machines. All they got to do is insert a USB device, get remote access. Now, these are just two examples. The court does not dive further into his extensive vulnerability findings, but the court's review of the full report does, at least at this juncture, find that there is appropriate evidence that have outlined several vulnerabilities. Now, besides the specific vulnerabilities in the new Dominion machines, like this is new. This is what is currently in existence right now. Dr. Haldeman's report further opines on broader risks flowing from those vulnerabilities. He explains that the risk of ballot manipulation is far greater when BMDs are used for all in-person voters like they are in Georgia, versus when BMDs are used for only a small fraction of voters who may require special accommodations. When only a small subset use BMDs, even if an attacker changes every one, the attack could only affect an outcome, a small subset, which means that successful fraud would not be effective. It requires a much larger scale. Now, he also highlights the growing risk of an attack on Georgia election by various adversaries, domestic political actors, election insiders who may be able to manipulate this, voters, and hostile foreign governments. He says Russia targeted Georgia's election infrastructure in 2016, and others might be political. He says election insiders and ordinary voters could also be recruited to do this stuff. He also references a Senate Select Intelligence report saying that the SSCI noted that the Russia, got it. Now, Haldeman acknowledges that all voting systems face risk. There's no realistic mechanism to secure all of them. But here are the main conclusions in his report. Based on the 7 particular vulnerabilities, this is a federal judge putting these in an opinion, says these are the conclusions. The BMDs in Georgia, the voting machines, are not sufficiently secured against technical compromise to withstand vote-altering attacks by bad actors who are likely to attack elections. The BMDs can be compromised to the same extent and as or more easily than other systems that they replaced. Do you hear that? Even more easily, like they went backwards. Now, despite the addition of a paper trail, malware can still change the individual votes and most election outcomes without detection. Although outcome-changing fraud conducted in this manner could be detected by a risk-limiting audit, Georgia requires a risk-limiting audit of only one contest every 2 years. So the vast majority of elections have no such audit assurance. And even the most robust risk-limiting audit can only assess an election outcome. It cannot evaluate whether individual votes counted as intended. Vulnerabilities also make it possible for an attacker to compromise the auditability of ballots. They can alter the QR codes, and cheating could not be detected with a hand count, since all records of the voter's intent would be wrong, right? You can't decide how they wanted to vote because you got 2 options. Using these BMDs for all in-person votes, just like Georgia does, greatly magnifies security risks. And the critical vulnerabilities and the wide variety of security issues indicate that it was developed without a sufficient attention to security during design, during software engineering, and during testing. It would be extremely difficult to retrofit security into a system that was not initially produced with such a process. Unreal. He's like, the whole thing is bad. Like, whoever designed this is a moron. So the court provided this condensed summary. Full thing is 66 pages, and it contains significantly more information. And so the exhibits are not included, but the court has the copy, which is available. Now, they say the next big development occurred when CISA got into the picture. 6 weeks after the Haldeman report that we just learned about, the Curling asked the court to authorize them to share the report with CISA so that CISA can go take a look at it. The court authorized Curling to share the Haldeman report with CISA. And guess what? CISA confirmed many of the vulnerabilities identified by Haldeman, but also noted that it found no evidence that these vulnerabilities have been exploited in the elections. Yeah, like maybe you can rig it, but nobody did rig it. CISA has stated that to exploit these vulnerabilities, a malicious actor would need to have physical access or otherwise have the ability to modify the files, blah, blah, blah. And they said, we're unaware at the time. But CISA did confirm it. And they detailed a series of mitigation steps that Dominion should use to prevent these things. Now, according to CISA, Dominion represented that many vulnerabilities that had already been addressed in later versions of the software. And so they said, just update your app. Now, despite this, a number of critical software updates related to this have not been purchased or installed in Georgia. like, oh man, you're charging us for that DLC pack? I got to pay for the new gear? Oh man, all right, well, it's too expensive. I'm not going to pay for it. This game sucks anyways. Besides, using up-to-date software and firmware, CISA also recommended other mitigation steps, like ensuring that all affected devices are physically protected before, during, and after voting, which was obviously not happening. We saw the footage. Image cast machines are not connected to any external networks. Yeah, right. Carefully selected physical security measures, blah, 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 right? We've seen the people who are in charge of these systems. They're all idiots. Not all of them. We have great respect for the good people, but many of them are. They're the people who set this up. Like, they built this whole thing. Look at it. As another mitigation step, CISA recommended that jurisdictions conduct rigorous post-election tabulation audits, and it emphasized that Georgia should do it too. It said, these audits are especially crucial to detect attacks. A barcode is manipulated to be tabulated inconsistently with the human-readable portion of the ballot. But they say to date, no evidence has been presented that the government of Georgia have even implemented CISA's recommended mitigation steps. Why would they? They got the vote they wanted, man. They got Democrats in office. They voted for Biden. It's like perfect. The system's fine. All right, it's fine. Software is great. Does everything we need it to. They need to upgrade everything. So the next recent development came from this other company called Fortalece. They conducted an assessment. Unlike Halderman, who focused on the vulnerabilities of the equipment, Fortalece used the Secretary of State's external public-facing websites and its internal network. They were probing the Secretary of State. After testing for weaknesses in Brad Raffensperger's external and internal systems, they identified 8 vulnerabilities with different ratings. Now, they give us a couple things. 4 vulnerabilities with high risk, 3 medium risk, and 1 at low risk. Here's the things. Insecure passwords, repeat passwords, overly broad file sharing, internal systems, failure to maintain software packages, and so on. Now, despite this report, again, the government has not remediated any of these risks. They just don't care. Eventually, the most serious breach of this began on January 7th, the day after the attack on the Capitol. Plaintiffs brought this revelation to the court. Broadly speaking, there was a Coffee County breach. Various individuals got access to Coffee County voting equipment. They were copying, downloading stuff, sharing data. And this is a declaration of somebody here. Many others, the acts were committed by a number of individuals, including the Coffee County Republican Party chair, Kathy Latham, Misty Hampton, and others. Scott Hall, Sullivan Strickler was retained, and the companies, the Cyber Ninjas, were involved. Now, they've opined that the above described copying and broad, they're saying that, yeah, like even that accessing of that, right, by these people who are investigating it shows how vulnerable this is. Now, the state claims that they first learned of this in February 2022, over a year after the breach began. Okay, so like in other words, Cyber Ninjas and these people went and got access to things. The government didn't even know about it. During Sterling's deposition, counsel for the coalition plaintiff played a recording from March 2021. They explained how they were all there. They just began copying the software. Like, let's check it out. Everyone else is copying it. Let us check it out. Now, although the state defendants assert that they did not learn of the coffee breach until the depot, the state was aware and, in fact, investigating other problems, and we've already discussed that below. On January 7th, 4 employees from a forensics firm called Sullivan Strickler traveled to Coffee County elections. They copied some software. They were there 7 hours, forensically imaged a number of election equipment items, and they just got access to it all. And they said they got a lot of stuff. The management server system, the central count scanner, 18 flash memory cards, a mobile printing laptop, 7 USB drives, application software copied. All this stuff was copied. Now they say here, Halderman said that the files contain the most important information that someone would need to develop attacks against the BMDs. So, and, you know, they got the whole software, right? In other words, so they can reverse engineer it and do whatever they want with it. Now, election software and data is uploaded and accessed onward. Now, after collecting this data, the Sullivan-Strickler team uploaded all the information onto the internet, an internet-based file storage, and anyone on ShareFile, 5 or 6 individuals downloaded the information. Some of these individuals may have further distributed the software. It's probably on a torrent file somewhere all over the interwebs. One individual who downloaded the data testified he converted the forensic images of the server into virtual machines, uploaded those machines, and he could basically recreate the whole thing. At least 10 people downloaded that. On January 18th, 4 individuals, also from Cyber Ninjas, also got access. And you can just, the fact that they got access alone is showing vulnerabilities. So arrangements were made for the material to be downloaded and distributed further. And once they learned about the breach, they didn't do much about it. The breach began in January, lasted almost a full year, over a full year. The state was aware of and was even investigating other issues. In fact, the Secretary of State posted a YouTube video about manipulation of the software. And the Secretary of State's communications were talking about passwords no longer working. So in other words, they were just totally, competent. The first election-related issue that the government knew about involves a YouTube video posted by Supervisor Hampton. In the video, she discusses various ways that the Dominion election software could be manipulated. And the video shows Hampton sitting in front of a computer with a note written on it. The Misty Hampton video was not the only election issue that they were investigating. So they knew that this stuff was being accessed and they weren't doing anything to remediate it at all. Besides these 3 issues, there was an investigation. Passwords were also being shared. And here's what we've got, some emails. Barnes explained that there would be part of the reason why he contacted the Secretary of State's office. He says, I'm concerned that there's some data that's compromised. 4 days after receiving the email, the Director of Elections responded, hey, James, thanks for sending this. I think it might be prudent to see if there's been any contact between the persons on the card and anyone in your office, if they have access to any of your equipment. I'll let our investigations division and CES know, and they may follow up with you. Let me know if you have any questions. Now, ultimately, they did replace some things, but no other equipment was followed up with. Now, nearly a year later, Raffensperger's office opened an investigation into the breach. And when asked later about his comments, Raffensperger said that the reason why they thought nothing had happened there was because that people that we had interviewed we thought were truthful. And they learned about the breach later. Then they tried to undertake a forensic evaluation. Brad Raffensperger's office contacted Dominion to try to get access to EMS. However, Dominion was unsuccessful and they failed. A month later, they referred the matter to the Georgia Investigation Office and they're investigating it. Now, 2 months after this, okay, so the point is all of this is showing that when you go in to vote and you expect your vote to be counted and it to be legitimate, it's not, right? Because they can't even investigate the people who got access to all the machines. So the current posture here is that we're filing a lawsuit, and with all that background out of the way, let's see what the judge tells us. The government wants summary judgment. They say, we've done nothing wrong. They say, the court lacks jurisdiction over the plaintiffs. They don't even have standing to challenge this, and it's all moot, the election's over. Plaintiffs say, we've got plenty of evidence. We should at least be able to present this evidence at trial. Now, the court says, before diving in, the court notes many of the parties have different arguments overlapping. She's going to deal with standing. She says the plaintiffs, the defense, the government says, you don't have standing. You can't come and sue us. And she's going to get rid of that, obviously. She says, yes, they do. And we'll fast forward through standing. We're all familiar with standing. They're actually injuries in fact. If you don't, if you can't vote legally, then you are injured. And all of these people have been highly involved. They say, this is the judge writing, against standing arguments. CGG's diversion of resources is closely connected, like it's not speculative, okay? So the harms that are befalling the people are real. The injury is real, it's imminent. There are substantial risks and long-run threats posed by this system if we don't get it fixed. Among other evidence submitted is Dr. Halderman's testimony. He says the DRE system before it and the BMD system, they relied on out-of-date software. The software is a serious security risk. There are public vulnerabilities. Nobody's fixing these things. Significant evidence that the election systems are targets of hacking. And numerous government reports, even from CISA, confirm these things. But based on this and other evidence, we said, yes, these are not hypothetical. These are not remote problems. Guys got to do something about it. And so here they're pointing to evidence to show that there are claims here. CISA supports it. And critically, the ongoing revelations about the Coffee County equipment breach also lend support, saying that these systems are at serious risk of breach. Halderman has testified. They say, in sum, the plaintiffs argue that the record shows that there are, quote, inherent design flaws, critical security failings, futile protective measures, advanced persistent threats, widely leaked voting software and data, extensive outsider access to voting systems and its operational environment, continued use of equipment in subsequent elections like 2020 and probably 2024, and persistent inaction by defendants have manifested plaintiffs' concerns to a degree that seemed unthinkable years ago. They filed it when it was bad, but it's gotten much worse. And they say, ultimately, after once again diving into the risks, this is the judge, that have been brought here, the court concludes that for the purposes of summary judgment, plaintiffs have presented enough concrete evidence to support the concern and the fear that there is a substantial risk of injuries to its members and their rights to vote and have their votes counted as cast if they're required to vote in the Georgia system. And because they've shown that they have diverted their resources and that the injury is cognizable, they've satisfied standing, right? And traceability and all of this. So let's fast forward through the standing stuff. They've been harmed. If you can't trust your vote, then what's the point? So we're still sticking with standing. The remaining plaintiffs also have standing, or I think she's going to make a standing ruling. She addresses mootness. Are the claims moot? Well, the election's over. I mean, it's over. What are they complaining about? I say, yeah, I mean, it's over. They say the state has already completely transitioned. We're already on the BMD system. But the plaintiffs say no. These new things are not totally moot. We still have claims even under the new system. And while any challenges to the DRE machines no longer present a controversy, those are old, they still can challenge the evidence about the BMD system. And so, merits of the claim, we're getting ready for trial. They say, are these claims violations of the Constitution? And they're going to basically be finding that there's sufficiency here to move it forward to a trial. Let's see how the judge concludes this up. A lot of heavy lifting on this opinion, as you can see. We're going through the constitutional analysis and the various steps. Pick up the pace here. And let's see what else we wrap up with in this section. A lot of scrolling. I apologize for the scrolling. All right, ballot secrecy. They say the BMD system deprives them of a secret ballot. We got large, bright screens. They say the systems are also bad because the scanner settings don't work. Scanners show more blanks in each race, and the check boxes and the ballots and the X's don't work right. In the latter part of 2020, there were complaints, so they modified the scanners. This resulted in a larger number of hand ballots that were being reviewed, and so they're identifying all the problems here. All right, so here, poll books, poll pads are problematic, and in conclusion, Judge Totenberg finishes. She says, the importance of security, reliability, and functionality of state election systems, classified by the U.S. Homeland Security Department as critical national infrastructure, cannot be overstated in a world where cybersecurity challenges have exponentially increased in the last decade. The dynamics of how a breach in one part of a cyber system may potentially carry cybersecurity reverberations for the entire system for years to come exemplifies the importance of this case. The constitutional voting claims raised here involve complex evidence, legal issues, and events heated by the political stresses of the era. But still, the court reminds the reader that the fact that this order allows the plaintiff's constitutional claims to proceed to trial, with some exceptions, simply means that there are sufficient factual disputes underlying the legal disputes that require a trial. We can't agree on the facts. But as stated, the judge is kind of, hedging here. As stated at the outset of this long order, collaborative efforts to address the issues might be more productive for the public good. So the legislature should fix this. I can't do it as the judge. But for the reasons articulated above, the defense, the government's motion for a summary judgment is granted in part, so some claims and some issues are done, and it's denied in part, meaning the plaintiffs can move forward. The motions are granted as to the plaintiff's claims, count 1, 2, but denied as to the other claims. And here it says, under the umbrella of the substantive BMD claims and the plaintiff's collateral theories and the relief requests that are related to ballot secrecy, scanner settings, paper backup ballots, are for the most part outside the scope of the case. With the following express qualification: evidence regarding the functioning of the poll books and the poll pads in connection to the operation as a whole. Additionally, as discussed, the plaintiff's asserted harm is not traceable to Fulton County, and so that's connected as fault. Motion for summary judgment as to Fulton County, granted. Anyways, trial is scheduled for January 9th, the current pretrial schedule outlined previously. And so, my friends, that is it. It is ordered this 10th day of November, signed by Judge Amy Totenberg, United States District Court Judge. We're scheduled for trial in January. And what's going to be curious about this is if we see that there were significant problems as presented by the plaintiffs, what of that will be relevant and useful in Trump's cases? In Trump's January 6th case, where he said the election was rigged, the election was problematic, there were problems. His call to Brad Raffensperger to talk about votes was legitimate. Maybe the concerns where they were counting votes and they just stopped counting in the middle of the night because of a water main break, maybe those were actually concerning. So, monster order from a federal judge out of the Georgia Federal District Court for the Northern District of Georgia. The judge's name, Amy Totenberg. And so trial is scheduled for January. And my friends, of course, we'll be here to continue to cover it. I do hope you join us as we do. There's going to be a lot of Georgia activity. We got the big Fannie RICO case, which is heating up. And of course, the other Trump prosecutions. But as more and more evidence and more cases work their way through the courts, I think we're going to see more of this type of stuff. It's hard to deny. These are bureaucrats who can't hardly run anything appropriately. Everything around us is failing and dysfunctional, but our election systems are perfect and they were the most secure ever? No. It was bad in 2018. It's bad in 2020. They're going to try to paper over it to get them past 2024. We're not going to let them do it. Thank you for joining us as we continue to cover this case and more. Thank you for subscribing and visiting robertgovea.com to sign up for our daily newsletter. We'd love it if you shared this content with a friend or family member so that they could see all the things that they're doing in this country. And we'll look forward to seeing you on the next one. All right, my friends. Well, we covered some good ground on the day. Some big stories today, of course. Big a ruling out of Georgia District Court. Trump wants the trials televised. He's probably not going to get it. And of course, the defense starts their case in the Trump New York City trial. lots of good stuff to attend to. But of course, now let's hear from you and see what you have to say about this before we go on over to our members only after party, which is where we'll hang out and debrief some of the stories, some of what we talked about here today. But I do think we're running a little short on time, so we'll have a shorter after party today. But let's see who we've got here in the house. Man, I always lose track of the clock, man. I have too much fun with you guys. All right, who's joining us? Woo! We got Kathy. Kathy is a new supporter over on the YouTubes. And for our YouTube friends, make sure you grab the private Telegram link, which is linked over in the community tab section on YouTube. Scroll down. Just keep scrolling down. You'll find it. It's down there. I'll post a new one soon. We got Kathy. Welcome as a new supporter. Great to see you here. Let's see who else we got joining us on the lovely day. Catherine Rex is here. What's up, Catherine? Over on the tubes. Says, sup, Rob? Happy Mod Monday. It's new. You like it? I love it. Yeah, I love saying Happy Mod Monday. Shout out to the mods. Modding down the fort for us. And good to see you, Catherine. We got CF Rob over on the Rumbles as a membo and supporting us on the Rumbles. Shout out to our friends on the Rumble. On the Rumbles. We got CF Rob says, so, bot, make me a piece of art that can be printed on canvas that I can launder money with. And remember, my dad is sitting right here. We're waiting for the money to be transferred. I think, are you saying maybe Rob? Or are you talking to your Chat GPT bot? Either way, sounds like you're going to make a lot of money, probably from the Chinese. Enjoy it. Be safe, though, out there. We know what other people do with that money. Voice says, the Trump New York City mistrial will be denied. Absolutely true. Remember Cohen lying on the stand and the judge allowed it? Yeah, Cohen, who's a convicted perjurer, was like the star witness for Tish. Give me a break. Says, remember when Tacopina's mistrial motion for the judge interference in the Carroll case? This is disgusting political lawfare. From our friend Voice of the People. Good comment, Voice. And you're right. I do. You know, the Tacopina trial, so the E. Jean Carroll case was pretty bad, but the Engoron case is much worse. Like, this is a total insanity. I mean, and actually, the E. Jean Carroll case was also nuts. That Judge Kaplan was also, out there. But that's what we're dealing with in New York and D.C. It's good to see you, Voice. Sean Wookie's here. What's up? Been a membo for 4 months. Welcome, Sean. Glad to have you as a membo. Says, thank you for making this news bearable. Man, well, thank you for being here, Sean. It wouldn't be bearable if it was just a solo activity. I really enjoy having the conversation with you. We're in it together, my friends, and it's going to be a lot of fun. A lot of difficult times, but we'll have some fun too. Wendy Sloan is here. What's up, Wendy? Thank you for the nice dono. No question on that, but Wendy, I appreciate it. Thank you for being here and for dropping in the nice dono. Hey, Bill. Bill D became a supporter. Welcome aboard, Bill. So we'll see you for our members, by the way. We do member streams in the morning, members only streams. We already had a member stream this morning. It was incredible. The best thing. We do after parties. We do Saturday shows, and we got some other cool stuff cooking, and I'm excited to share it. Bill, good to see you. We'll see you in the morning on the after party on the show. And if you want to join the after party, join the Telegram link. Just download the app and grab the link from the community tab section. Ravicus is here. Said, now I gotta cut ya. Okay, I'm not sure who that nice looking person is. Okay, that's a scene from an Eddie something movie. We'll leave it there. Good to see you, Ravicus. The Blind Lawyer Explains. Says, you ever look up the net worth of Graceland? Do it. Yeah, I did. It's $400 to $500 million. This is from Donut Mind Me. Clipped it for us. Thank you, Donut. Who answering the question. The mansion and the property were acquired by Elvis for $100,000 in 1957. The estate was estimated to be worth $400 to $500 million. Oh my gosh, according to Rolling Stone. Yeah, it's that brand value, man. What's up, Chubby Stubby? Says, if it wasn't so blatantly biased, how Chutkan cherry picks which local rules to ignore and which to follow, it'd be a nail biter to see how she'll rule on the airing issue. Yeah, I mean, I think you're being facetious, obviously, Chubby. But yeah, it'd be a nail biter to see how she rules on the airing issue. On the TV issue, I think she's going to hard nut. She doesn't want anybody like measuring her rulings. No, they don't want anybody to see what they're doing in there. They'd rather have Maggie Haberman write about it, about how they're saving America. Thank you, Chubby. Good to see you. We got Knox Bierman. Says, so the media will make a witness lie, not very solid witnesses. Right, Knox. Knox is an attorney from Texas. They can't control their witnesses in their own courtroom. What are they doing over there? We don't get to participate in a historic trial because one of their witnesses might make like a funny comment or something to showboat for the cameras. Okay, big deal. We need to get him in line, right? The judge can deal with it, but we should not be able to see it accordingly. All right, good to see you, Knox. Glad to have you here. We got Jarbot. Says the media doesn't want it broadcast so they can characterize it however they want. Yeah, they don't. Every time Trump gets control of the narrative, he wins, right? Like his big arrest in Georgia was all dismantled with a mugshot. I'm going to put his mugshot up out and all these, people were going to rub his face in it. And then he puts it on a t-shirt, sells $5 million or whatever. He wins. They lose. That's why they're going to have to keep him gagged. Box Lane Productions says Joe Biden walks into a bar and then a table and then a chair and then somebody helps him off the stage. Good to see you, Box Lane. Good to see you on the tubes. Knox says court TV shows criminal trials all diddly doo-dah day long. Nobody melts down. You're right. There's a whole company around it. And, think about one of the biggest trials that we ever saw was that Johnny Depp trial. Wasn't that whole thing, we didn't cover it here, but wasn't that whole thing, live streamed and nobody melted down? I'm like, okay, it's trial. We get it. Like we're the American public. We get it. We live for it. All right. Good to see you, Knox. We got Spud says, wouldn't WAPO have a problem with the denial since they say democracy dies in darkness? They do say that. And then they wreck democracy with their terrible reporting. So I don't know, but I think they should be in agreement with Trump. We should all see this trial. We got 1R5. What's up, 1R? Over on the Rumbles. Good to see you. Thank you for the nice dono. Says, is Judge Engoron's sweetie under oath? You mean his Allison Greenfield, his GF? No, I'm sure she's not under oath. She's just an employee. She doesn't have to swear in and testify. If not, how is she allowed input during the trial? And as always, thanks for the great work. So she is like literally his law clerk, right? And he's like getting notes from her and stuff. I don't know what's going on. I don't know if she's massaging him or whispering in his ear or like tickling his neck or something. I don't know what it is, but it would be good to know. And if Trump's lawyers were not gagged, then they could tell us. But since they're gagged, they can't tell us if they're playing footsie or foot massages or neck massages. I don't know, but who knows what's going on. But no, she's not under oath. She's just an employee over there. And she's definitely the judge's Greenfield. We got Catherine Rex says, you should put a motion in, Rob. White House Coke photos were leaked. I saw that. I saw the cocaine photos were leaked. I think Hunter's crack or, Hunter's, Coke at the White House. Where would I put a motion in? For the media? Put a motion in for Judge Chutkan? Your Honor, watching the watchers needs the live stream. Stop wrecking America. Sign, yours truly. All right. Good to see you, Catherine. Chubby's here. Says, gee, interesting how a 2017 election fraud case going to trial, yet all the 2020 cases were filed summarily dismissed without even an investigation into any of it. You're right. All gone. Like they all got, almost all of them. A large portion of them got dumped immediately. They said, sorry, it's moot. Sorry, no standing. Sorry, it's not, ripe if it's too soon. And they moved all the COVID rules and they told us it was the most secure election ever. And we just read through 135 pages of fraudulent problems in Georgia. But we're all conspiracy theorists for thinking differently. What's up, Jarbots over on the Rumbles? Good to see you, Jarbot. Says, this is likely why Willis is issuing plea deals in Georgia. They're terrified to allow discovery to the Trump team of this election case. She's not ready for trial. Totally agree. Totally agree. And there's been a lot of other lawyers who disagree with me, actually, saying that these plea deals are smoking deals. They are. They're dismissals. Every plea deal she's offered is going to be a total dismissal. Gone. No convictions. No guilty plea will be on their record. Nothing. Jenna Ellis, Sidney Powell, all of them totally exonerated as though this never happened. Why? Because she's not ready for trial. They're all diversion deals. Because there's no case here. Trump's right. There were problems with this. He's allowed to speak freely about election problems. They indicted him. They're trying to, I think, rub his face in it. Again, I really don't think that they care. Even like they'll get convictions and then he'll appeal them and probably win, but the damage will be done. It's the first past the post. They just have to keep it together until the election's over and then they don't care, right? Because Trump will basically age out at that point. We got B-Man says, Nina Totenberg from NPR says the RNC better lawyer up or it's going to be 2020 all over again. No doubt. It's already happening, Totenberg. We're already watching it, okay? Like we're watching 2020 in slow-mo right now. They're trying to keep Trump off the ballot. They're going to try to make election changes, right? They're fighting in tooth and nail in all the various locations around the world. We've got around the country. Stephanie Womack is here. Says, I joined this channel for Rob to cover this case. Hey, what's up, Stephanie Womack? Been a member for 21 months. That's 2 babies and then some. Man, I got like a whole like little entourage over there at Stephanie Womack's household. Man, 21 months, Stephanie. Super cool. Thank you for being a member for so long. Said, I joined this channel for Rob to cover this case. Well, we finally did it. It took 21 months, but we got it. Here we are. Thanks, Stephanie. I really appreciate you being here. And that's a fun case to cover. I'm glad we got it in. Rocky says, this is insanity every day. Thanks for the group therapy, Rob. It helps. Well, thank you, Rocky. It's like, it's like I said, I mean, if we didn't get to have this conversation with each other, I'd just be sitting there on my phone like, you sons of friggin', all the things. And I'm glad we get to do it together. It's nice. All right. Good to see you, Rocky. We got Facts Matter says, clip and share the heck out of that last segment, peeps. Mind blowing. Yes, please do. Please clip anything, re-upload it, share it. It's all fair game, right? Just go hog wild. I care more about the information than I care about the views on the channel. I'd rather you take it, share it, do whatever you got to do with it. I'd rather more people just see it. That way we can have more people wake up. We need the votes, we need the votes. I like the viewers, I like the subscribers and things, but I'd rather have a, saved country. Then we'll get the votes. We can have both. All right, let's see who's joining us on the X platform. Very briefly before we wrap it up and go say what's up to our friends on the locals. We do have a couple people joining us. 12 viewers over on the X. Woo! Woo! All right, we're in double digits, baby. Things are getting pretty crazy out here. All right, let's see what else we got on the X platform before we jump over to locals to wrap it up. We got Fred says, Fanny knows all about this. Why on God's name would she indicate 18 people about this? Indict 18 people. Can she be that stupid? Did she not think this would come up? Like the 150,000 million missing ballots? Good to see you, Fred. Danny says, my brain hurts again. Flash River says, Rob, this evening you've unfolded. Flash River. Flash, oh man. Flash says, Rob, this evening you've unfolded much like the swift and agile cheetah, gracefully traversing vast expanses of judicial territory. And then you elevated it to hypersplain, providing a thorough elucidation of the intricate thoughts within the minds of legal eagles. Thumbs up. Nice. Thank you, Flash. Oh, thank you, Flash. We did traverse vast expanses of judicial territory, my friends, and it was a tremendous traversion. We got Raven is here, says, I recall the O.J. Simpson trial. Country was captivated. Better than watching J.R. Ewing. And Troublemaker says, the machines were created so that agencies can change the results. We got George over there, says, great show today. Much good news. Great job as usual. When things really get going, are you going to expand to two full shows a day? I don't know. We do member shows. We kind of do. We're going to stick with the members only. Samantha's over there. Other side of the mountain is over there. Says, Judge Totenberg is the sister of NPR Supreme Court correspondent, Nina Totenberg. Wow. That is a curious one. Okay. And so, my friends, that is it for us on the X. That is it for us on the day. We are going over for a very short members only after party at watchingthewatchers.locals.com. Whatever we don't get to, we'll be sure to hit in the morning tomorrow when we come back for our morning stream. Don't forget to check out robertgovea.com where you can sign up for our daily newsletter, get access to all the show reports, lots of good stuff over there, including a mind map tutorial video. If you want to learn how to use the mind map and access this exact mind map, you can do it over there. Fieldofgreens.com. We're going to be hearing from them every now and then. Save 15% with code Robert at fieldofgreens.com. Shout out to our mods and our meme smiths modding down the fort for us and keeping things nice and beautiful and orderly. Donut Mind Me clipping for us along with KB in this morning on the day. Good to see you, Donut. Thank you for this. Dog Digger, Janik 909. We got John Allen. We got Zach Nichols, Beyond Geo, our friend Zulu, Ronnie Cole, Playing Hooky, Just Cause, K-Bean and our friend Vienticus Prime all modding down the forts for us. Shout out to our meme smiths. We know Gigum Gigum, Nathan, N810, and our friend Sleepy Dog Lee over on the X platform. But my friends, it is a beautiful Monday. Grateful to be back here with you this week. It's going to be a busy one. We're going to have more Trump trial stuff and a lot more litigation to attend to. So thank you for subscribing. Thank you for sharing this with a friend or family member. We are going to be here back tomorrow to get into it all again. And we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.